call in probation. I don't know what happened over the weekend. Friday they told me they'd have it done Saturday, or at least meet with him and figure that out. But they were going to make calls. In the meantime, just take up this deadly weapon intent by the state to seek the affirmative finding, because that'll, if I do that, he won't be eligible for probation, and we don't have a right to a PSI. But I want to hear arguments on both sides, and then quit.
Yes, Your Honor. Of course, yes, the court noted the state did file a notice to seek a deadly weapon finding in this case. I think based on the facts that were presented in the trial, the actions of Mr. McDonald, either by kicking or an object unknown to the grand jury, led to her death. It's very.
I'm sorry, can you speak up? It's
of course, yeah.
It's hard to hear.
No, of course, yeah, especially kind of the buzzing noise. Yes, Your Honor. Based on the finding of this jury and the facts presented in this case, in terms of either Mr. McDonald kicking Andre McDonald and causing her death, or causing her death by an object unknown to the grand jury, based on the jury's findings, it clearly indicated that it was something that her demise, her loss of life, was due to a deadly weapon. At least one of those two different options, potentially even a hammer, based on the evidence as well. Based on all of those, I think it's clear that her loss of life was due to a deadly weapon, and because of that, we'd ask that you make that finding based on not just the jury's finding in this case, but also because of the facts presented.
Okay, defense.
Yes, Your Honor. We would call the court's attention to a Court of Criminal Appeals decision, Duran versus State, from 2016. May I approach the bench?
Yes.
I would call the court's attention to pages 4 and 5 of that opinion. Duran does an excellent job of laying out the history of how deadly weapon findings are made, discussing Polk, and later LaFleur, which modified Polk's holding. The long story short is, Your Honor, there is absolutely no legal way for the state to get to a deadly weapon finding now, as this jury's verdict was returned. First, there is nothing in the indictment that gives notice of their intent to seek a deadly weapon finding. There is no mission of a deadly weapon. The language used is manner and means unknown to the grand jury. Secondly, there is nothing in the jury charge that authorizes the jury to find a deadly weapon. And third, there is nothing in the jury's verdict that makes that conclusion necessary. In particular, in Duran, the court noted that if it is not alleged in the indictment, there is no per se.
Were you reading?
I'm sorry.
Were you reading?
We're on page 5.
5. Okay.
In the top. If the indictment specifically alleged a deadly weapon, then that would be one basis. If the indictment did not use that word, but alleged the use of the deadly weapon per se, such as a firearm, then it could be allowed.
I haven't read this case. Obviously, you just gave it to me, but is this going with the jury, though? Or is this also going to a judge?
This is about going to the jury, and the issue is this.
Because that's completely different. If it's going to the jury, it's either as charged in the indictment or a special issue. But if it's going to me, that's and I heard the evidence and it's not going to the jury, that's a different thing. This case has not gone to the jury, then to the judge for punishment.
You're asking me whether it's distinguishable because it was a jury punishment as opposed to a judicial punishment?
Correct.
Let me look. I'm not sure. I don't believe that that's controlling. The issue is, let's just back up and take it to first principles. First of all, a deadly weapon finding creates a secondary class of punishment for the defendant in the sense that his eligibility for parole is curtailed in a dramatic way, which has the effect of increasing his total punishment in a way that would not exist for a non-3G offense. So there's an apprendi concern out of the gate. In other words, the trier of fact, the jury, did not have an opportunity to consider this question. And so whether it would ever be the province of you, Your Honor, as a judge sitting in punishment, to have the ability to come back and reassess that decision, I think apprendi forecloses that consideration. Because due process mandates that the defendant have notice of that intent at the beginning, that the trier of fact that was deciding his guilt or innocence passed upon that question, and then and only then can it be used to increase his punishment. Because the parole eligibility factor makes, for example, a 20-year sentence a much stiffer 20-year sentence than if it's a non-3G offense. We believe that apprendi would be applicable. The idea also would be that while the court certainly was entitled to hear the evidence and make its own considerations within the range of punishment authorized by the statute, fundamentally, this court's power of the sentence is tethered to the findings of fact that were made by the jury in the trial of the case. In other words, Your Honor would not be able to assess a punishment for a more serious offense. Your Honor would not be able to make a finding that would be expressly prohibited by something that the jury found by special issue. It would have to be consistent factually with what the juror trier of fact already experienced.
I'm trying to just haven't gone through this whole Don Jr. versus State of Texas Francisco. What I was asking you versus the jury versus punishment versus me, because I've looked at some cases myself over the weekend in Fan versus State, and it's a 702 Southwest 2nd, 602. That's a Texas Court of Criminal Appeals. It basically says that trial judge is the fact finder in the punishment phase authorized to make an affirmative deadly weapon finding. If I heard the evidence on the deadly weapon issue and the trial of fact in the guilt innocence phase did not decide that matter. So the jury did not decide that matter. In addition, Florida's versus State in 690 Southwest 2nd 281 also Court of Criminal Appeals, because trial court was the trier of facts of punishment of the stage of the trial. He had the power to add the affirmative finding to the judgment if the fact showed, and he believed, which was me, that the defendant himself used or exhibited a deadly weapon during the commission of the offense. So I'm trying to conflict what you're telling me, but obviously you're telling me this is going to a jury, which that's quite my distinction. And as far as a notice to all the cases that I'm looking at is he was indicted by murder, and I know they're fact specific. Some of the case laws are talking about that, but a lot of courts held that was sufficient notice that he committed an act clearly and dangerous to human life by manner and means unknown to the grand jury. There's several cases that say that. In addition, I don't see how you, besides that, how you can say we had notice when he gets up here and testifies that he kicked her, and I don't see how there's any lack of notice in that.
A foot is not a per se deadly weapon. Right? This isn't a pistol case, it isn't a knife case. A foot can or cannot be a deadly weapon depending on the manner of its use. That's the only way it becomes a deadly weapon. And we're talking about reckless use of the foot. Right? This isn't an intentional case any longer. I think that those findings implicitly reject the idea that a deadly weapon is appropriate, because had the jury thought that the manner of use was consistent with our definition of a deadly weapon, then they likely would have chosen the more serious offense. I think that
and that's what I'm. And the case, sorry, the next case is the Polk versus State, and that's also Texas Court of Criminal Appeals 693 Southwest 2nd 391.
Yes,
that's also negligent homicide, in that since the jury didn't make that, the trial court made that affirmative finding on his hands, using his hands.
In Polk, that was authorized by the indictment, and it was submitted to the jury for their determination. The application paragraphs in our jury charge in this case are...
I'm sorry. It was citing Polk. It's Crumpton.
Okay. Well, Polk is sort of the fountainhead of this subject. And I think most cases are going to draw on Polk's reasoning, which in LaFleur the court acknowledged was somewhat flawed and had to be modified. But the takeaway from LaFleur is, as Duran points out, did the indictment specifically allege a deadly weapon, or did it allege something that is a per se deadly weapon? And, or did the jury make an express finding of fact of the use of a deadly weapon in response to a special issue? One of the things that Duran asks the court to consider is also, what was the jury charge on this subject? While the court did include application language in the murder charge to include kicking, the manslaughter application paragraph in this case, in our trial, did not include a specific application statement about kicking. It just simply tracked the manner and means unknown. So we have a jury that selected a verdict option that expressly omitted the same factual recitation that was alleged in the murder case. So I think based on that, we could make a fairly good contention that had the jury found him guilty of murder, they implicitly were making a finding based on the application language, which included kicking. But the manslaughter application language doesn't include kicking.
I still don't see where it has to be guilt innocence thing, but go ahead.
The note that the jury sent to us in this case, I think, is also important to consider. The jury asked whether failing to call 911 was an act really dangerous to human life, which telegraphs to us that their consideration was less about whether or not the foot was even the approximate cause of the death necessarily in comparison to what was done later, what were his actions or inactions at a later time. Bottom line, the state of Texas was in control of this journey the whole way. They could have given us a deadly weapon notice at any opportunity prior to this.
I mean, obviously that would have been better, but I just don't see that it needs to with this indictment. But go ahead.
I think every case that we're discussing here, the deadly weapon allegation was authorized by the indictment and was authorized by the jury charge. The idea that Your Honor gets to completely reinvent the factual universe through the sentencing process runs contrary to what the jury authorized here. We can't.
I don't get away that it could have been the hammer, it could have been his feet. I mean, it's an issue that I could decide. And listening to you argue, we know cases have said hands, and we know they've said feet as deadly weapons, and he testified that he used his foot.
But it's about notice that it's going to be applied against us. An allegation that in the manner of its use it became a deadly weapon. The jury properly passing upon that question. The idea that those things can now be supplanted in the sentencing process simply because he was made an election to go to court, it undercuts all of those premises. It means that in order for you to enjoy your due process right to notice and your due process right to have the trier of fact pass on this question, the only way that you can be secure in it is if you go to jury punishment, which undercuts one of the only choices the defendant gets to make in the entirety of his own defense. I mean, it would be strange for us to craft a rule that completely jettisons these requirements simply because we decided to go to the court instead of the jury. And especially when we think about what are any of these requirements in sentencing about. They're about making sure that when the defendant ends up in sentencing, that he knows what he has paid for. He knows what he's bargained to get to that spot in the proceedings. If he doesn't have notice of the deadly weapon in advance, then he can't make an intelligent decision about any of the things that he needs to make in order to decide whether to testify, whether to go to the judge or jury for punishment. It impacts his strategic processing through the course of the trial. And, I mean, again, we're not talking about something purely administrative here. We're talking about something that has a tangible impact on the final punishment that he receives and the length of his prison term that he will serve, and increases the maximum length of that prison term because in addition to making his parole eligibility a further and further remote possibility, it also affects his mandatory release date. So I think all of those factors being considered, without authorization in the indictment, without the trier of fact having had the chance to pass on it, I don't think that this court can come back and resurrect it now. And again, it would be inconsistent. We submit very inconsistent with what the jury found here. We know that this jury...
Yeah, I mean, I think you're completely wrong on it. Deadly weapon is a punishment thing, but you can finish up.
No, I think we've made our arguments there. My final objection would be that this was a process that was instituted in open court after the verdict had been announced and at the request of Your Honor, asking the state if they had an intention to file this. And I think that under Blue versus State, that raises an independent concern because it creates the appearance that the court is somewhat directing this court.
And even if they didn't file it, they filed it this morning. Everything that I've seen case law, they didn't have to. I think the indictment's sufficient. Your defendant testifying what he did is sufficient. So I wasn't even sure if they were going to do it this morning, and if they didn't do it, I'm still leaning it that way anyways. Go ahead, State.
Yes, Your Honor, it's very great. Of course, as the court pointed out, punishment, the deadly weapon binding is a punishment issue. Even in the case that the defense decides was something that when the defense argues that this jury didn't have an opportunity to do so, they're not deciding punishment, the court is doing so. So it's a completely different issue. Secondly, Your Honor, under Apprendi, and also just the indictment itself gives the defense notice that there is a deadly weapon aspect based on the fact that it is murder, based on the manner of means under the jury, and then subsequently when the court gave the alternative charge about keeping it itself. So those notices are all there for the defense. Furthermore, in Crumpton, as the court, I believe, cited earlier, in that case when the jury found the defendant guilty of criminally negligent homicide, the Court of Criminal Appeals still held that the one deciding punishment, in that case, the trial court, the judge, still had the authority to find a deadly weapon finding. So under all of those, we believe that it is appropriate for the court to make the decision in terms of deadly weapon finding, and that notice has adequately been given by the indictment.
Okay. I'm going to go ahead and make a deadly weapon finding, and either the feet to that he testified, or it's also possible the hammer. Okay. Probation, you don't have the PSI ready. I mean, they're not entitled to it now because it's probation's off the table. But if it's done, I mean, I could give it to them either way.
Judge, so they interviewed him on Saturday morning?
Yes. You're right there. It's fine. Go ahead.
So probation interviewed him on Saturday morning. We received restitution information Saturday, and I believe the steps came in late Saturday. So PSI is working on it with the understanding, when I spoke with you, to have it ready by this Wednesday.
Okay.
Because he had said the testimony would be for Monday, Tuesday, and then we'll have it ready for Wednesday.
So try to get him to get it as fast as possible. But again, I don't need to consider it. He's not entitled to it. So if it doesn't come back today or tomorrow, we're still going forward, and he doesn't have a right to it. Okay. I'm just trying to make it happen anyways.
We just wanted to note our objection to that. The 42A requires the PSI, and at the time it was rushed, and we objected on Friday. The court had them do the interview and do it over the weekend. The statute would have provided us with at least 48 hours. Not the court, the statute would have given us an opportunity to read and review the PSI 48 hours, at least 48 hours in advance of sentencing. The rush to judgment in this case is deprived and prejudiced us of that ability. Moreover, the statute says that it should include his military records. I haven't seen it yet, but I'm objecting in advance because you're pushing us forward in advance, and I object.
And that's fine. I don't have
Continuing to do.
Hold on, Mr. Connery. That's fine. He's not entitled to a PSI. He's looking at prison only, and I've done that before. And attorneys argue that. They go look at the code and they say, okay, well, you're right. He's not entitled to it. So I guess you haven't looked at that either. Okay, so I'm just not going to get it to you at all. We'll just make it easier. Okay, first witness.
State calls Colonel Richard Garrett.
What was the last name, Steve?
It's Eric. It's spelled E-R-R-E-D-G-E. First name Richard. I'm sorry, E-R-R-E-D-G-E. Gotcha.
Your cell phones are off.
I can have this witness. I didn't ask any opening from either side. Punishment.
No, Your Honor.
You have a seat. You raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Go ahead.
All right, thank you, Judge. Yeah, Colonel, can you state your name for the record?
Yes, sir. It's Colonel Richard Erich.
And Colonel, what is your position?
I'm the 960th Cyberspace Wing Commander.
And can you briefly explain to the court, what duties does that entail?
So that entails commanding, administrative purposes, and making sure our reservists are on mission with the proper authorities and proper pay statuses.
How many people are under your command?
1,300 approximately.
And you're stationed here in San Antonio?
Yes, sir. JBSA Lackland.
And how long have you been in that position?
I've been in this position since August of 2020.
Now, Colonel, during the time when you began that position in August of 2020, did you have a Major Andre McDonald under your command?
He was in the wing, yes.
Now, if you could explain to the court kind of how many degrees of separation between yourself and where Major McDonald was?
Sure. Major McDonald is in a squadron, and then there's a group between me and him, and I'm at the wing. So there's two levels of organizational structure between me and him.
Now, Colonel, what I want to talk to you about now is just in general purposes. When a member of the Air Force, are they required to provide for their dependents?
Yeah, so the Air Force implements law and regulation that requires supported dependents.
Now, of course, that could also be individual state law as well, correct?
Yes, sir.
So, but the Air Force actually has an authority for members to provide for their dependents.
Yes, sir. We have policy that implements the law.
Now, Colonel, earlier Judge Castro heard testimony in terms of Major McDonald being arrested on it'd be March the 3rd of 2019 on a tampering with evidence charge, and then subsequently a murder charge on July 13th of 2019. Now, to your knowledge, was Major McDonald, did he continue, what was his status with the Air Force when those took place?
At that time, he was in an active duty status.
Now, during that time that he was in active duty status, did he continue to be paid by the Air Force?
Yes.
Roughly how much was he paid on a monthly basis?
On a monthly basis, approximately $10,000 a month.
So, Colonel, at some point, did Major McDonald's status with the Air Force change?
Yes, in April of 2022, he changed to a traditional reserve status.
And I assume when he changed to a traditional reserve status, his monthly income was affected. Is that true?
That is true.
Roughly how much, or how would it be affected, and what type of numbers are we talking about?
So when you're a traditional reservist, you only are paid for the duty that you perform, and roughly the drill pay for a traditional reservist, if they perform normal duty, is about $1,000 a month for a major.
Now, Colonel, at some point in the fall of 2021, did it come to the attention of the Air Force in terms of any obligations that Major McDonald was failing to undertake?
Yes, on November 8th of
Before we proceed any further with this, I want to make one objection for the record. That we don't have this individual on our witness list. I understand the state gave the 404B notice, or I guess a 3707 notice of their intention to discuss this topic. But I don't believe we received notice of this witness. I don't believe we have any statements from this witness.
Here's one.
Your Honor, I did serve notice. He is on the witness list that was tendered to defense on December 28th, 2022. The Colonel was added to the witness list at that time. There is not a statement that the Colonel gave.
Well, we would object to the untimely resignation of the witness. That was done just days before the trial began. And for all of our previous objections to this, I think that that's untimely disclosure.
Your Honor, under the defense's motion for a witness list, they asked that it be done 20 days prior to trial. The trial started on January 17th of 2023. This is more than 20 days.
That's what I was looking at right now. It's just, yeah, it's before. Okay, I'll allow to testify.
Now, Colonel, I believe where we left off was, did it come to your attention in 2021, excuse me, that Major McDonald was failing in his duties?
Yes, on November 8th of 2021, we were notified that he was not supporting his dependent child. And so I issued an order on the 9th of November to take care of his child. And the 10th of November of 2021, that was delivered to him.
Okay, so Colonel, just so I'm clear, you received notice that he was not supplying financially for his child in November 2021.
Yes.
And that order, what is the process? How is that done by you, and how is it served on Major McDonald?
So it's generated by my staff, and then I sign it. It's a direct order, and then it's hand delivered to him by the squadron commander.
Now, Colonel, at that time, do you acknowledge that Major McDonald provided any financial support for his daughter?
After that time, he did begin providing financial support to his daughter.
Do you know how long that financial support lasted?
I do not know.
Now, Colonel, in terms of a service member with the Air Force, are their dependents provided access to base for various services?
Yeah, so if you're an eligible dependent in the Defense Eligibility Enrollment Reporting System, they have access to the installation with an ID card or with an authorized sponsor who has access to installation.
So when you say an authorized sponsor, in a situation where someone is incarcerated, how would that individual go about actually getting any of their dependents' services? What can they do to make sure that they're provided for?
So there's two ways. One way is to have somebody that has authorized an installation take care of that member for you, or they can generate a power of attorney that will allow somebody that they appoint access to the installation so that their dependents can get whatever services they need.
Now, are those services to an individual who's incarcerated, are they provided free of charge to that service member?
Yes.
Now, Colonel, in a situation like this, where a service member has been found guilty of a criminal offense, what is the next step that the Air Force undertakes?
So the Air Force will request all the evidence from the case, and then we'll consult with our legal team, and then the Air Force will make a decision on what to do going forward.
So, and Colonel, does that process not even begin until you have all of the evidence available to you to make that decision?
That is correct.
And to be clear, you were not the actual individual making that decision. That's done by consultation and someone else in the Air Force.
That is correct. It's not my decision.
Who is making that decision?
So that'll be the General Court Martial Convening Authority, which in this case would be Major General Brian Radcliffe, my boss.
And where is the Major General?
He is stationed at Carswell Air Force Base in Fort Worth, Texas.
General, that's with us.
Your defense.
Morning, Colonel.
Morning.
I'm John Conford. I'm one of the lawyers for Major Andre McDonald. You've already testified that you're at least 2 levels above Major McDonald in the chain of command. Is that a fair statement?
Yes, sir.
You came, it's my understanding, to San Antonio while he was already incarcerated. Is that a fair statement?
That is correct.
And that Colonel Cadillac would have been his commanding officer at that time, correct?
Yes, sir.
Are you even in his chain of command with respect to Colonel Cadillac's ratings?
I am in the chain of command, yes.
Do you approve his OPRs?
I do sign the OPR I sign all officer OPRs.
Okay, so the January 02, I think, of 2022, the rating that I think covered the 18-19 period, did you sign off on that?
I'm not sure. I have 1,300 people, so I may have, but I don't remember.
So you can't remember if it was a very good rating or how Colonel Cadillac rated it?
I do not know, no.
Okay. But you would have been, when I say signed off on it, meaning you're improving the thought.
I am signing the form, yes.
And not to downplay it, that's one of the Air Force's most significant, greatest management tools for its officer community, is it not?
Yes.
Now, with respect to a person in jail, you knew that for a significant period of time, Major McDonald was in the Bexar County Jail, did you not?
I did, yes.
And then you knew that he was under extremely restrictive conditions of his release to his home. Did you know that?
I did know that, yes.
Did you ever go and visit him?
I did not.
Did you ever personally communicate with him?
I did not.
And you're not a JAG, you're not a Judge Advocate General officer or office. That's you're referring to as the legal team.
Yes, I am not a legal officer.
You're not a legal. I understand. And that you're vindicated to the prosecution that that's where this will go next. Correct?
I don't understand the question.
Well, the prosecution had you say that what's going to happen now is that we get all this evidence and it's going to go to the legal team in consultation with the command to determine what to do, correct?
Yes, sir. That's normal processes for the Air Force.
Just like it's part of the normal process in deciding who's going to charge someone at all.
Yes, sir.
There's a decision made between law enforcement, legal, the judge advocate, the general, as to is the state of Texas going to proceed with this prosecution, or is the Air Force?
That's true. Yes, sir.
Okay. And then after that, or even during that period of time, my understanding that there was already a letter of reprimand issued, is that correct?
Yes, sir.
And then after the letter of reprimand, there was the beginnings of, while he was still on active duty, there was the beginnings of an administrative procedure to have him exit the Air Force for misconduct. Is that correct?
So we requested evidence from the state in order to make a determination on what process to go forward next.
Your command filed the administrative process to have him put out of the Air Force for misconduct. Is that a fair statement?
We did start, yes.
And that process, during the long period of time that this has been pending, that process is just laid there.
That process has been on hold, yes, depending on the outcome of this trial.
And with respect to the issue of one taking care of their dependents, that issue came up to you through the chain of command. Is that fair?
Yes, sir.
Okay. Were you aware that Andre McDonald at or around the same time period you're talking about, November, December 2021, went into federal court and waived any claim at all to Andreen McDonald's or their insurance proceeds?
No, sir.
Were you aware that a trust has been set up with $580-something thousand for the benefit of his single dependent man?
You said he waived in federal court, and he
Waived completely.
Okay.
And I have the
Were
order.
they,
I'm going to provide a court.
was it a hearing to see if he gets it and contest it, or he just, and that's when he waived at that time?
I have the court's order from Judge Pulliam that I'm going to provide later in the proceedings. Go for the question.
And you said it was 580,000. I'm trying to read the records.
The exact number is in the order, but I believe it's over $575,000 plus the other half of the insurance proceeds paid off one of the mortgages on an assisted living facility property.
Okay, and that would go to the child now, and for her care.
That's correct. It's in probate. There's a trustee. Judge, there are civil administrative things going on outside this.
And he obviously did that before the conviction, because I'm assuming he was convicted, he wouldn't be entitled to it anyways. But this was done in just 21.
Correct.
Okay.
Fall of 21.
Okay. Good. State.
Yes, Your Honor. Colonel, during the time that Major McDonald was incarcerated, did his command or members of the Air Force visit him to ensure that he had any needs that needed to be taken care of?
Yes.
Now, and as defense counsel questioned you about that, you did not personally do that, but people that were directly his commanders did so.
Yes.
Now, defense also questioned you about the process in terms of separating Major McDonald from the Air Force through administrative procedure. Is it common in which there's a civilian case as well as a potential case with the Air Force to wait for that civilian case to be resolved before evidence is turned over to the Air Force?
I'm going to object. That's a legal question. It calls for speculation on the part of the witness.
And he brought up the issue on his cross-examination.
You're asking if it's
Not in the same-
what their position is to do with the Air Force?
I'm asking if it's common for evidence to be then turned over to the Air Force so they can make their decision after the civilian case is resolved.
You can answer that.
Yes, that's very common.
Well, that's what it is.
Nothing further.
Okay, thank you. Excuse me.
And, Your Honor, before we begin with our next witness, the state would offer evidence. State's Exhibits 439. These are bank records by Andre McDonald. discovery with a business record affidavit since July 22nd of 2022. And the defense for any objection.
I would object in part because these records contain materials that address procurement of legal services, and we believe that they're privileged.
That's what it talks about in there? I mean, details.
There are records within the records that are about procurement of legal services related to this case. We think that's privileged information.
What are you trying to get in those records? Something
Your
besides
Honor,
that?
no, it's strictly just his bank records.
Bank records.
So if there had been a check cut to the defense, there's no actual statement given. There's no violation of attorney-client privilege in that situation.
We would think that the actual source of the fee and
That's
how
fine.
the fee is paid
That's fine.
is
I'll
part of the issue.
sustain it. I don't need to see it. I'll sustain the objection.
Your Honor, it's 21 pages, kind of very small font. We needed another minute to go through it. It's not something, we had it in discovery, 6 terabytes of information, but we want to make sure that we're close there.
I sustain your objection.
To the whole exhibit.
That's what you're objecting to.
I mean, yes, I'm objecting to the whole exhibit.
And it's just his financials at that time, or what?
It's his financials at that time, Judge. What the state would offer, either we could strike those, or I could simply just submit the page in terms of those balances to the court.
Okay. Any of the objections besides the ones you already objected to?
I would need just a second to...
That's fine. You can take a look at them.
Your Honor, we would object for a couple of reasons. First of all, this is a joint account that's shared with his sister. And there are a lot of other factors to Mr. McDonald's finances and to the estate of Andreen McDonald that are currently in probate that I think in fairness would need to be considered in conjunction with this for it to have any meaning.
So he shares it with her?
This account is a shared account.
Your Honor, he gave the sister power of attorney after the offense took place to the account.
He gave her, okay.
And Your Honor, it's to the defendant's sister, Noel, that is who he gave access to.
Yes, that's what
It's fine, I'll sustain it. I'll see it.
So, Your Honor, I would just mention that you're not allowing the financials on just the page with the amount.
Is that what your objection is?
Our objection is to the whole exhibit and that one page.
We just have to just do that one page. That way it separates any specific checks written to, say, for example,
Counsel?
defense counsel.
Stuff
Yes.
like that? Okay, then what exhibit number is that?
It's
It's now 439.
That's the one with the attorney funds and whatnot.
439 is the complete record, Judge. I can either mark it as 440 as to that individual page.
Yeah, I'll grant it to the individual page, the rest I can look at.
And Your Honor, here's Exhibit 440.
Okay. I'll let you continue with witnesses. I don't know what this is going to show me, though, is alleging that he's spending a lot of money, because then I don't know, and I don't care, but he spend a lot of that on attorney's fees, and it doesn't make any, unless you're going to tie it together with something else later. Okay, next witness.
And Your Honor, before the next witness, I just want for the record, my understanding is Colonel Eric just to fly out, so we just ask that he be excused.
Anything, can you fly back?
The witness that just testified?
Yes.
Correct. I have no objection.
Yes, he's excused. And just for the record, before we call the next witness, I just wanted to cite the exact, I was flipping through the book here and find the exact code that I was citing that he's not entitled to the PSI. It's 42A.252. Judge is not required to direct a supervision officer for pre-sentence or report in a felony case if the only punishment available is imprisonment. There's some other exceptions too that it's not entitled to, but that's the one I was looking at.
I understand, Your Honor. Our concern also is...
I already made a decision, so you don't have to...
Well, I need to clarify something else for the record.
Okay,
which
it's
is
denied.
there's-
Pick your next, let's sit down, Mr.
Your Honor, respectfully, I just need to make sure that this is made for the record.
Yeah, I've already let you make all your arguments for the record. Get the next...
But this is not an argument I have to make.
Okay, I've already made my ruling. Go
I
ahead.
understand that.
Next
but
witness.
this is
Next witness.
Judge, this name was called Warren A. Anderson.
I'm going to object to being denied the
That's
opportunity to
fine.
make my record.
That's fine. You can make a record or proof to the court reporter later, but I've already heard enough of that. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God? Please state.
Thank you, Judge. Warren, can you spell your first and last name for the court reporter?
LORNAANDERSON.
And, Warren, can you introduce yourself to the judge?
Hi, I'm Lorna Anderson. I'm Andreen's aunt.
And you said you're Andreen's aunt. Can
Yes.
you tell me how you're her aunt? Like, how are you related to Andreen?
Paul Anderson is my brother, and
And
that's Andreen's dad.
And just so the judge is aware, which I think he's heard testimony, but can you tell us, did Andreen have any children?
Yeah, one daughter, Andre McDonald.
How old is Elena?
She's 11, turning 12 in April.
Now, Lorna, can you tell the judge a little bit about Andreen growing up as you knew her?
Okay, as a child, Andreen was very smart. She was brilliant. Just the things that she would do, I know that she was going to be a good wife. I say this to say because I was living in Canada, which I still live, and Andreen was in Jamaica. When we go to visit, Andreen would always wake us up early. Andreen would always wake us up early. She'd start cleaning up the house, and she'll try to make breakfast. It wasn't anything great, but the fact that she would try. She was very loving. She was just very happy, and she had this radiant smile. Like, if she comes in a room, it doesn't matter what. You always see that big smile. She always had such a big smile.
There's some tissue there.
You mentioned you live in Canada, correct?
Yes, I do.
And did you live in Canada while Andreen lived first in Jamaica and then in Florida and then in Texas?
Yes, I've always lived in Canada before Andreen was born.
Were you and Andreen, however, still close?
Yes, we were very, very close. Andreen was like my own daughter. We would talk about everything. She was just like my best friend. She always confided in me. She would tell me a lot of things that she wouldn't tell anyone else.
And what was the main way that y'all communicated since you were in Canada and she was here in the United States?
We would talk by WhatsApp, or we'll call directly, because it's usually free for her to call and it's free for me to call from Canada to the U.S.
Would you also come visit her at times here in Texas?
I did before come and visit her. She was having this big birthday party, and she wanted me to come. There's other times that she'd want me to come, but the times that she wanted me to come, I wasn't able to get holiday. But, you know, we had our own holiday over the phone. We talk, we joke, we laugh about things.
And did she come visit you in Canada at least once?
Yes, she did. She came to visit us once, 2018, June 2018.
And when she came to visit you in Canada, did she have Andre and Elena with her?
Yes, she did. She came with she came as a family.
Now, you mentioned June of 2018. Do you remember getting a call from Andreen on July 4th of 2018?
Yes, I did.
And do you remember when you got that call? I don't want to get into what necessarily Andreen said, but when you answered the phone, did Andreen seem scared?
Okay. Sorry. I'm usually excited when, we talk to each other. So that evening, Andreen called, and I said hello, and she didn't answer. The only thing I could heard was Andre on top of his lungs, screaming, calling her names, calling her a whore, calling her trash, calling her a bitch. And what I heard Andreen said, Andy, because that's what we call him. I don't call him Andre, I call him Andy. We all call him Andy. And Andreen keeps saying, Andrew, you're choking me. Stop choking me. Stop choking me. And one at a time, Andreen, because she was driving, and I know, she said, I knew this because she said, I'm driving. And she said, you're covering my face. Stop scratching my face. And you still continue on. And she was very, very, I could tell by the sound of it, she was very, very scared because she keeps calling your name and you still continue to do what you're doing.
This is July 4th,
This was July 4th of 2018, correct?
Yes.
And as Andreen was yelling, did she seem like she was scared?
She was very scared, because she keep calling out his name, telling him to stop, and he wasn't. And she keeps saying, I'm driving, you know, I can't see, and he still continue. And she even said, you're scratching my face, stop scratching my face, stop covering my eyes, stop choking me, and he continue on.
And you mentioned you heard Andre yelling things
Yes.
through the phone.
Yes, he was calling her a bitch. He was saying she was a trash. He was calling her a whore. Okay.
And Lorna, was it your understanding that Elena was with him?
Yes, because after the fact, I asked her what was Elena doing, and she was on her tablet. You know, that's usually their distraction. She's on the tablet.
How did that phone call end? What happened after you heard all those noises? And
Just the screaming, and then all of a sudden I don't hear anything, and I starting to get scared. I keep calling the phone and no answer, and right there and then I was just like, oh my God, he killed her.
you were in Canada at the time.
I was in Canada at the time.
Can you tell the judge how helpless that felt, being so far away?
It was very hard. I called so many times, like just keep calling. I was so scared. And nothing, back to back. And at that time, I didn't have his phone number until after. The next day, later on in that evening, she called and she said she's okay, but she can't talk and she'll talk to me after. And I said, are you okay? And she said, I just like my throat where he was choking and the scratches. And she sent me the picture right there. And
Laura, we saw a picture during the trial. Was this a picture of Andreen's face with scratches on the front of her face?
yes,
And were those pictures that she sent to you?
she sent it like right away.
Lorna, did you talk to Andre after that happened?
Yes, I did.
Can you tell the judge how that came about?
Okay. After I spoke with Andreen, I was really mad. I was so mad. And I said, listen, I need to talk to Andy. And I need his number because his name is not Paul Anderson. And your own dad would never do such thing to you. She gave me the number and I call Andy. He answered the phone because I guess Andreen told him that I was going to call. And when he said hello, I said to him, I heard what happened yesterday. I was on the next end while you were carrying on. And I said, what was the purpose? I don't understand. I don't get it. Like, why were you trying to kill her? Because she's driving and she's screaming that you're choking her. So what was the point of that? He turned to me and he said to me,
That's the comment from the defendant.
The issue is not that. The issue is the statement she just testified to.
Judge, we're not offering that to the truth of the matter. We're offering it for the effect on the defendant where there is an exception.
It's being offered for truth.
What did Andre say when you told him that?
okay, when I said that to him, I wanted to know, okay, why he was doing to her, why he was doing that to her. He said to me,
Again, Your Honor,
But-
objection. That is being offered for the truth of the matter, sir. The question is to imply that it's the truth, and that is a recitation of it, and now we want to see what the answer to the question is, but those questions, the testimony about those questions is hearsay.
And at this point, Judge, we're getting into his statement, which is not hearsay.
So
Can you tell us now what Andre said to that?
And I said to Andy, I said, okay, what was the cause of all that? Why were you doing all of that to her? He said it had something to do with a tattoo. I said, what tattoo? He said that Andreen had a tattoo that he just noticed on her wrist. And I said, okay, so Andreen have a lot of tattoos, so I don't understand. I said, I don't pay attention to all the tattoos that she have. I know that she have a lot of tattoos. Andy said to me, the tattoo meant something to her. And I said, well, what does it mean to her? Because it wasn't adding up. He said that it had something to do.
Your Honor, this entire recitation is hearsay.
It's not hearsay.
Hold on. You don't answer this objection, okay?
Okay, sorry.
Go ahead.
Objection, hearsay.
Same response?
Same response, Judge.
Okay, it's overruled.
And he said the tattoo had something to do with a guy named Albin. I said to him, I said, who's Albin? And he said to me,
Hearsay, Your Honor.
Okay, I'll sustain that. I already know who Albert is.
Can you just tell me what Andre said to you at that point?
because this is what that's how it started.
Just what Andre said. Not
Okay.
what you were saying to him. What did Andre say?
Okay, he said the tattoo had to do with Albin, and Albin is a guy that Andre knew a long time ago, and I said, okay, and
Objection, hearsay.
Okay, sustained.
Tell me this.
Andy said that it had something to do with Albin, and I don't know, I said, who's that? And he said,
Here's what we're going to do. Just tell me what Andre said to you. Only his words, not what your words were to him.
Okay.
Just what Andy told you during that
Andy,
conversation.
okay, sorry. He said to me, Andy said the tattoo had something to do with Albin. After that, he said, Andreen is seeking attention from Albin because she went on Facebook and she liked something that he posted.
During this conversation that you had with Andre, did he deny the assault that happened to her on July 4th?
No, he did not.
Did he attempt to justify it?
No, he did not. He didn't.
What I'm saying was he trying to give excuses as to why it
Objection,
happened?
asked and answered.
Okay, sustained.
He was just,
Objection, asked and answered.
Well, I'll wait for the next question.
okay.
So Lorna, after that conversation, was that a scary situation for you to be on the phone while this happened?
Yes, it was very scary.
And did you have concerns after hearing that in the marriage between Andre and Andreen?
Yes, I had a lot of concerns.
Were you concerned based on what you heard on the phone and based on your conversation with Andre? Were you concerned for Andreen's safety?
Yes, I was.
Now that we know kind of what happened to Andreen, is that something that bothers you still to this day, those concerns you had?
Yes, it does. It hurts every single day.
And Lorna, I guess let's talk about Andreen's not here anymore, correct?
Yeah.
And do you recall how you first heard that Andreen was missing?
Yes.
And can you tell the judge how it felt when you got that phone call?
I started to cry. I was at work and I was crying, and I told my coworkers what happened, that she was missing and we didn't know. And they started to look up numbers for hospitals in San Antonio. I called so many hospitals just to see if she was in the hospital. I used the name Andreen Anderson. I used the name Andre McDonald. She wasn't there. I was, because some of the conversation, like when they're arguing and how he was, I was so scared. I wanted to be positive, and at the same time I'm thinking he did something to her. I called his phone too, and he didn't answer.
After she went missing, did you come to San Antonio?
Numerous times.
While you were here in San Antonio, did you participate in searches for her?
Yes, I did. I gone with my brother so many times looking for her, hoping that he's somewhere. And we always have like water just in case he's somewhere. And he was dehydrated, and there's water that we could give to her.
And so during that time that y'all were looking for her, y'all were holding out hope that your niece was still here.
Every day I was like, please God, just let her be someplace. Like, he just kidnapped her. Every single day. It was very hard. I couldn't function.
Now, Lorna, eventually they did find Andreen's body, and can you talk to the judge about the difficulty you had since it was confirmed that Andreen died?
When it was confirmed that it was her, I started to cry so hard. I had to take some time off work because it was like very, very difficult. My doctor, he said I can't go on like this, so he gave me antidepressant, and since then I have been taking it because there's days when I'm driving and I'm crying. I miss her so much. I miss her smile. We always joke about her white teeth and my white teeth. And we joke and said it's an Anderson thing because our teeth are so white, hers and mine. And everybody always said we look alike. We always joke about who's cute. And I said, well, we look alike, but I'm the older one, but we're still beautiful because we're Anderson.
Were you proud of all the accomplishments that Andreen had?
I was very proud of her. Very, very proud of her.
Do you believe she would have had more accomplishments if what happened on that night didn't happen?
She would have. Because she always, from a child, she just doesn't want to stop at one thing. She wants to go higher and higher. That's the type of girl she is.
Do you feel like Andre stole the ability for you to see?
Yes, he did. He sure did.
Lorna, do you see Andre here in the courtroom today?
Yes.
Can you point at him and identify him by a piece of clothing that he's wearing?
Yeah, he's wearing a red thing with a mask under his face.
Now, Lorna, is there anything else that you'd like the judge to know in terms of sentencing on this particular case about Andreen or about how y'all dealt with this? Is there anything else you'd like the judge to know?
With object to relevance, Your Honor. That overall calls for sitting on the file.
Yes. He left the family.
I'm not asking that. I'm not, I guess, wanting to hear anything about this is how much time we want, or this is what.
Okay.
Anything else,
So,
not that, but anything else.
all right. So, personally, I would like for Andy or Andre McDonald to get the maximum.
But I think what he's saying is we're not talking about amount of years. Is there anything that you would like the judge to know?
I don't want to know anybody.
Oh, sorry, okay.
Just about Andreen or how this is dealt with. Is there anything else that I forgot to ask you that you want him to know just about Andreen or the situation or how hard it's been on you?
Oh, okay, my bad, sorry. Okay, well, it has been very, very hard on the family, like super, super, super hard. Like, hard. Even when holidays come around, when it's her birthday time, knowing that she's not around, it's very, very hard for the family. and hard for me especially.
I'll pass the witness, Your Honor.
Thank you, Your Honor. Good morning, ma'am. You spoke with the District Attorney's Office back in April of 2021. Do you remember that?
I might have. I spoke to them different times, so.
You've spoken with them quite a bit. Very same? Mm-hmm. When was the last time you spoke with them before today?
Spoke to who?
The prosecutors.
I talked to them this morning.
Before today, I mean, have you had meetings with them throughout this process?
On Friday, we were here together, so we did talk.
Have you ever reviewed any of your written statements that you've given to the District Attorney's Office?
No.
But you recall that in April of 2021, you had a sit-down meeting with the prosecutors to discuss your testimony. Do you remember that?
I might have.
And you discussed in that meeting this incident that occurred in July of 2018 where you were on speakerphone with the McDonalds while they were driving back from Brownsville, right?
Yes, I was.
And you didn't tell the district attorney in that interview anything about Andre choking her or strangling her or anything like that, did you?
I would have said that because that's what happened. That's what I heard.
But it's surprising to learn that you didn't at any point tell them that back in April of 2021 when you sat down.
Judge, I object to improper impeachment. I don't believe she has a written statement. I believe what he's looking at is some notes that we have given him. And I don't think it's a proper avenue for impeachment.
Oh, no.
It's a statement. May I approach the witness, Your Honor?
Yes.
And now I'm showing you, regrettably, what I can't mark for identification, but suffice it to say it's a statement noted here. This is you, correct, Lorna Anderson? Mm-hmm. And you acknowledge this is a meeting dated 4/15/21, correct?
I don't know the time. I mean, like I said, I have numerous meetings, so I don't know.
Okay. Well, let me call your attention here to all right, this paragraph here that starts in July. If you could just read that to yourself briefly and let me know when you've gotten to here.
Okay.
Okay. That's your statement, right? I mean, that's the subject you were discussing with the district attorney back in April, correct? Mm-hmm. Can I get a yes or no?
Yes, yes.
And you don't tell the district attorney anything about Andre choking her or strangling her, correct?
I'm 100% sure I said that because that's what happened. That's what I heard.
Your Honor, I have to print this. I wasn't anticipating it. I'm going to offer as extrinsic evidence under 615 statement from April of 2021.
And Judge, I would just make the same objection. I don't have a problem with any questioning. The problem is the characterization of this as a statement. These are notes taken by us while we were speaking to her. They're not a statement that she's formally adopted as her own statement.
She just adopted the statement. That was the part.
Just asked her.
One at a time, one at a time.
And I believe...
Hold on. I just pointed at you. Hold on.
We've met all problems for the introduction of the exhibit. It's a statement of notes from their conversation with the witness. It is their taking down of information. They took it down to prepare for trial.
Who took it down?
The district attorney's office. They produced it to us as a statement from her. In fact, it's the only statement we have. And the witness has acknowledged that it is her statement. And she has unequivocally refused to acknowledge the factual recitations in the statement. And under the rule, I'm entitled to offer this document as extrinsic evidence.
Your response.
Judge, to be completely above board and out of an abundance of caution, we provided the defense with notes from our interviews with the witnesses. These are work product notes that we provided them, that we told them at the time, these are strictly notes. These are not word for word. These are just notes from our interviews with them. We did this in order to, like I said, above and beyond what was asked of us in discovery. We violent. That's the only argument I have, is that it's not an actual statement. It's not her words. It is our recitation of what she told us during it.
That's
Which
fine.
is it? The problem
That's
is-
fine, I'll get it out, and I still take into consideration the cross that, obviously they left that out, and it's not there, so I understand what you're getting at, but I don't need to see that.
I can't offer the document.
No, I'm gonna grant it because it's their notes, and, I won't have to look at it, but, I get your point.
I understand, Your Honor. Please note our exception, we'll be offering it for the record.
That's fine.
You went to go see the McDonalds in September of that year, 2018, right?
Yes.
And you told the prosecutors that that was a happy exchange, that there weren't any problems or conflicts that you observed, everyone had a good time.
Yes, it was a party.
You knew that Andreen was going to Jamaica to see Auburn fairly regularly, right?
No, I didn't know that.
You told the prosecutors that Andreen even called you from Jamaica at one point, right?
Yes, she called me from Jamaica because she told me she went to give a speech at the school that she once went to as a child.
And she would go to Jamaica often when Andre was on deployment or not available.
I don't live here, so I wouldn't know. I just go by what Andreen tells me. She's an adult. She tells me what she feels like telling me. She never tells me she was going to go visit Arbin.
And Andreen would tell you that she was going to Jamaica when Andre was out of camp, right?
She's never told me that she was going when he was out of town.
Well, Your Honor. So that's the reason.
Good thing. Thank you, excuse. Next witness.
Your Honor, the state calls Jennifer Applewhite.
And, Your Honor, we're going to have some objections to this witness, both under 702 grounds and hearsay and confrontation. So I guess to begin off, we request a hearing under 705.
Your Honor, this was Elena McDonald's behavioral specialist. She's not being called as an expert right now. She's specifically being called as a fact witness. We noted the changes that she witnessed in Elena prior to March 1st, how Elena acted prior to March 1st versus how she acted after March 1st of 2019. That's her own observations, and we're not asking for her to formulate any opinion as an expert.
Well, then we would have the...
She's not testifying to what, I know didn't come into the guilt innocence phase, but what the daughter may have witnessed with the fire sticks or any of that stuff.
Our
Or like
intent is
any
not to get into anything that would elicit hearsay. I think that Ms. Applewhite actually witnessed behavioral changes in Elena's day-to-day routine that she should be able to tell this court about.
That's fine. I'll deny your objection.
Good morning. Good morning. Could you please just spell your first and last name for Ms. Crawford?
Jennifer.
I'm sorry, Mom.
I'm stopping at the, I don't think the judge saw her.
Oh, yes, sir.
Please right hand. Swear to tell the whole truth, nothing but the truth, so help you God.
Yes, sir.
You know, just the microphone, you need to, please.
Now, could you please spell your first and last name?
Yes, Jennifer Applewhite, JENNIFER APPLEWHITE.
Is it just as a matter of,
background, could you tell the judge how you're currently employed?
I'm a behavior teacher, special ed teacher at Specht Elementary.
And were you employed as that back in 2019?
Yes, ma'am.
And so what is your basic education in order for you to do that sort of occupation?
I have a master's, but I started off as a recreational therapist, which I'm licensed in, and then about 10 years ago, I transferred into and got my certification as a special ed teacher in behavior.
And so just kind of briefly, like day to day, what are your responsibilities in that role at the elementary school?
We help the children that are in my unit to function as normally as and independently as possible and teach them ways to cope with stress or anxiety or any challenging behaviors that they have at the time.
So just kind of clarification, you're not like a lead teacher with a class, you kind of move as the students need to move.
Yes, ma'am. I have my own classroom that they can come to if they need a break, if class gets overwhelming or they get anxiety, things like that. If they need a quiet place to do work because work is becoming too hard, they can come to my room, and we also push into the classroom and help them in class as well.
Okay. And so did you provide some of those services and support for Elena McDonald?
Yes, ma'am, I did.
And how long were you, or is behavior specialist, is that the proper term? Or how would you characterize it?
It's special. It's we're called SPED, Specialized Education Professionals, but we're in the behavior. It's broken up to resource where they get academic. I get the behavior part of it.
I'll just keep it as specialist.
Okay.
How long did you work with Elena McDonald in that capacity?
Since she got to Specht Elementary in first grade.
So how old would she have been when you first started working with her?
5 or 6.
And so you started working with her at 5 or 6, and did that continue until she got older?
Yes, until just this last year.
Okay, so in total, how long have you worked with Elena McDonald?
About 4 years.
And so let's go back in time to 2018. Let's talk specifically prior to March 1st of 2019. So let's go to late fall of 2018, early winter of 2019. Could you just describe for the judge in general, what was Elena's normal routine at school?
She was a great child. I loved having to work with her. She was very bright, probably ahead of most of the kids in her class. She was very social for an autistic child. She liked to be in the middle of things. She liked to participate in activities that were around. She was very kind-hearted, had a bright smile. I mean, she made kids laugh all the time. I mean, she really was a pleasant to be around. She did have, times that she was anxious or things like that she'd come out of the classroom, but nothing out of the ordinary for a child that age.
So prior to March 1st of 2019, I think you said that you had a special classroom where students could go to if they needed to. How often would Elena do that? How often would she leave her regular class and then come to your sort of isolated room?
At first it was probably just like occasionally like a 10-minute break here and a 10-minute break there. She probably did 2 or 3 a day. It just was a place that she could come, get centered, do something that she really enjoyed doing, and then we'd get back to class.
Other than that, most of the time she was in
Gen Ed class.
Gen Ed class.
Mm-hmm.
And so did you interact with Elena on March 1st of 2019?
Yes, ma'am, I did.
And what were some of the things that you noticed about Elena on that day that you hadn't noticed previously?
She came to school with her hair messed up, not matching clothes, did not have a jacket. She did not have her snack box that was a lunch box that she carried every day. She just came in very disheveled, and that wasn't like her. She usually came in dressed top to bottom, matching every 2 coats, snacks all day long. Her hair was always done, had different color braids every week. It changed color beads, which matched her outfits.
And so then March 1st and later, how did Elena's behavior at school change?
She became more reserved. She didn't talk as much. She sort of kind of would sit to the side in the classroom. She didn't want to be around a lot of people. She would yell a lot in class. She would do what she thought she needed to do to get out of that area. She would say negative things. She would use inappropriate language. She would throw things. She would yell at other children, not just in class, but at recess. There were times that we had to go out and bring her in because she was just not playing appropriately.
And so I think previously you had said prior to March 1st of 2019, she may come to you, leave her general education classroom just a few times.
Correct.
Did that change after March 1st of 2019?
It did. She spent very little time in class. It was probably, she would go to class for 15, 20 minutes, and then she would come to me and we'd do the work the rest. She spent most afternoons from about lunch on with me. It was just too much. She would be very emotional and very mad at the same time.
And I guess at some point in time, did your team and the school in general have information that her mother was missing?
Yes, we did.
And so what was the focus for Elena at that time?
At that time, we had, our district has a crisis prevention. We had notified them, our school counselor, and tried to get as much support as we could that she would need at school to be successful.
So was it basically the grades and the coursework that maybe the other students were having to do? Was that the focus of importance for Elena?
Not at that time. For the rest of that year, probably even through May of that same year, it was just making sure that she was safe, that she felt secure, that she felt as normal as possible, that she could feel with everything that was going on, along with giving her the work. But we did it more in my classroom where we could do it more on a, quiet and private way instead of being stressed out and having people ask questions. There were kids that would ask her, and so it wasn't necessarily a good thing for her.
And I think you said previously that there were some times that maybe there were incidents on the playground where you guys had to remove her.
Mm-hmm.
Is there a specific incident that happened on the playground that caused you concern with Elena?
Yes, ma'am. The most, severe thing that she did on the playground was she was throwing rocks at other kids. And when the teacher approached her to ask her to stop doing it, she stuck the rock in her mouth.
You're saying confrontation.
Oral.
I'm sorry, could you please repeat what you were saying?
Yes.
What did Elena do?
She picked up a rock that was probably bigger than a quarter and put it in her mouth and tried to swallow it, and they called me. I came out and I got it out of her mouth.
Had Elena ever done anything like this prior to March?
No, ma'am.
2019? So then let's go back before Andreen McDonald went missing. Did you have opportunity to interact with her?
Yes, I did.
And how often did you interact with Andreen McDonald with regards to Elena's education?
We have annual ARD meetings to talk about her goals and things like that. We also talk to her about weekly just to go over how she was doing. Her mom was very invested in her schoolwork and checked in. She was very involved and wanted to know how she was doing, if there was something off or something that she needed to work on at home, she would. And so it was mostly weekly that we would talk.
And so in that weekly communication with Andreen McDonald, was that over phone or by email or some other method?
A little of both. A lot texting. She was very busy, and so it was easier sometimes to just do it that way.
And so with reference to Andre McDonald, prior to March 1st, 2019, how often did you communicate with him with regard to Elena?
Directly, not directly. He was in the ARD meetings, and I saw him on 2 occasions for special occasions that were at school in our classroom, but I never had direct conversations with him.
So is it fair to say that the regular communication about Elena's education was with Andre McDonald?
Yes.
That's what it's from.
Defense.
No questions.
Thank you. Excuse me.
Thank you.
Next witness.
The state would call Maureen Hyacinth Smith.
I believe this is a fourth one. How many of y'all anticipate calling tonight?
Judge, after Ms. Smith, we had 2 more.
3 left.
Yeah, 3 left, not Ms. Smith, yes.
I may want to look at the defense witnesses for afternoon.
No, we can't tell him.
I know, but I'm saying,
It's on his witnesses, I don't think it'll take much of the afternoon.
I'm just telling you to make calls to have them on standby or whatever to ready and watch. We only have 3 witnesses left.
Morning.
Have a seat. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Go ahead and speak loud enough into the microphone, state.
Ms. Smith, can you pull the microphone just a little closer to the end of it? Ms. Smith, we heard from you last week, possibly even the week before, but could you reintroduce yourself to the judge?
What did you say?
Can you just tell the judge your first and last name?
I am Hyacinth Maureen Smith.
And you're Andreen's mother, correct?
Yes.
Can you tell the judge how many children you have?
I have 2 children. Andreen McDonald and Cindy Johnson.
And Maureen, I wanted to talk to the judge about some things that had happened since Andreen has been gone. Is there any more Starlight homes?
No, there isn't. The
Did that business fail?
Yes.
Are you receiving any more money now that the business has failed from Starlight Homes?
No.
Without Andreen, that business wasn't able to go on?
No.
Elena has been living with you and Cindy, correct?
Yes.
You're not her mother and Cindy Ann isn't her mother, correct?
I am the grandma and Cindy is the mother.
But Andreen was her mother, correct?
Yes.
And was Elena close to Andreen?
Yes.
Has it been hard on Elena not having Andreen?
Very, very hard.
Can you tell the judge what it's been like for Elena not having Andreen in her life since 2019?
Elena cries almost every day in the early part when her mom was missing.
Speak a little louder.
Yes, Elena cried almost every day when her mom was missing, and she stresses a lot. She's picking her skin, and she wasn't doing well in school in the early part, and things that she sees happen to her mom affect her, and because of that, she's getting treatment until now.
And have you seen changes in her behavior that she didn't have prior to Andreen dying?
She's almost okay now, but in the early part, she was like very aggressive. She would like beat she would fight kids at school.
And did you believe it was because she was upset about what had happened to her mother?
Yes, I do.
Maureen, back in 2019, you lived with Elena, Andre, and Andreen at Solitude Cove, correct?
Yes.
It was a big, pretty house, right?
Yes.
Had a swimming pool in the back?
Yes.
Does Elena live at Solitude Cove anymore?
No.
Did y'all have to move to another house?
Yes.
Did Elena have to move schools from where she was back in 2019?
Yes.
She's at a new school.
Yes.
And she had to change all of her teachers and all of her staff that helped her with all the things that Elena has going on.
Yes.
Has financially, back when Andreen was alive, Andreen was able to pay for a good life for all of y'all, correct?
Yes.
Y'all don't have money coming in the same way anymore, correct?
No.
Do you work?
No, I'm not working at the moment.
Does Cindy Ann work?
Yes, she is.
And what does she do?
She works with the cable company. She's one of the customer service rep. But right now she's on 1 month break because of the case.
Cindy Ann doesn't make as much money as Andreen made back in 2019, right?
No.
The money that Cindy Ann does have, she's putting towards you and Elena to help you all be able to live, correct?
Yes.
Has it been difficult for you to step into more of a mother role for Elena since Andreen has been gone?
It's not really difficult because when Andreen was here, I am the person that take care of Elena while she goes to school and work.
But was Andreen a big part of Elena's life?
Yes, she was.
And so is it hard on you that Andreen's not around anymore to help you with Elena?
Yes.
Are y'all receiving any money from Andre?
No.
Is money something that's difficult for you and Cindy Ann and Elena since Andreen has been gone?
Yes.
Has it put Elena in tough spots in terms of where she's living and what school she goes to?
Yes.
Maureen, during the time that Andreen was missing, did you and Elena hold out hope that y'all would find Andreen?
Yes.
You were hoping you would see your daughter again.
Yes.
Did you participate in searches looking for her?
I didn't do searches because in those days I was like looking about the house, taking care of Elena, getting up early, sending her to school, and I have to be there to receive her when the bus comes. But doing all of that, I was worried, and I was hoping that she would come back alive.
Is it hard for you as a mother not to have Andreen anymore?
Yes.
Can you tell the judge a little bit about how that feels and how hard it is for you not to have her?
It's very hard because when I go back and I think how I had it hard in the early days to send Andreen to the school that she wants. Because I remember when she was age 15, she was going to high school in Jamaica, and she did her exam and she had 10 subjects, included English and maths, and she said that she wanted to go to college. and I didn't have the money to assist her at first. What I did, I had a nice bedroom set, and I sold it, and I gave her all that money to start the college where she want to go, and she was doing well, and she meet Andre, and she decided to come to America, hoping that everything would be well, hoping that she would pursue her dreams, and this is how it ends.
This is what last name
The
says.
last part.
This is how it ends.
Maureen, do you remember in November of 2017, do you know a Kadeen?
Yes.
Can you tell the judge who Kadeen is?
Caitlin is Andreen's best friend.
And do you remember in November of 2017, was Kadeen over at y'all's house on Solitude Cove?
Yes.
Do you remember an incident where Andre pushed Andreen and she fell on top of a baby?
Yes.
Were you there in the house when that happened?
I was upstairs, and Andreen and Andre was downstairs.
And can you tell the judge what you heard?
They were fighting, and she ran upstairs, running
Hold
from.
on, wait until you make the break.
We're going to object to lack of personal knowledge. She wasn't present for the event.
I think she's going through what her personal knowledge is right
She was there, right?
now. Correct. She said she's coming up, that she was upstairs and they're coming up the stairs for
Just what you witnessed, not
So, Maureen, just tell me what you saw. That essentially you heard them arguing, is what you said.
I
then they
heard
came
them, and
upstairs.
she ran from Andre, and she came upstairs, and he ran behind her, and he pushed her, and she fall on the bed, on the baby that was on the bed, Kadeen's baby.
So you saw this, that Andreen ran up the stairs
Yes,
and Andre was chasing her,
yes,
and then he pushed her onto a bed where a baby was laying.
yes.
Maureen, is there anything else that you want to tell the judge about Andreen or about how hard this has been on you right now?
It's very hard to know that, what I would say, Andreen, nobody is perfect. Everybody makes mistakes in life. If she do something to Andre and he is upset, I think he could do something else. He could resolve the matter in a different way. He's too intelligent for that. He's fairly intelligent. He's very smart. And I wasn't expecting this from him.
Thank you, Maureen. I'll pass the message back.
Defense.
Mr. Smith, you testified once already in this trial, correct?
Yes, sir?
And you talked about how difficult this was for you because you virtually loved everybody involved.
Yes. Yes, sir.
And in terms of this finances issue that the prosecution talked about, I want to draw your attention to that. You have an attorney, do you not, in the probate and the child custody issues that are being conducted outside of this courtroom?
Did you say about probate?
Yeah, Jean Brown. Hasn't she
Yes.
represented you?
Yes.
First, with respect to gaining the custody of Elena, correct?
Yes.
And then now there's a probate action going on, correct?
Yes.
And as part of that, back in November of 2021, I believe, November, December, the insurance company, you were aware the insurance company put the money in federal court from Andreen's insurance policy, correct?
Yes.
And up until that point, up until Andy got out of the Air Force, you were getting money for the support of Elena, correct?
He paid 4 months maintenance for Elena, and he stopped.
And then Enroy, is it? Enron, the fellow who was running Starlight Homes for a while, there's a number of $1,000 checks to you from him for the benefit of Elena, correct?
He paid, when Enroy was running the business, I was supposed to get $1,000 for maintenance for Elena, and I got $4,000 4 months because the business had gone down and he couldn't afford to pay that money anymore, and he told Andre about it.
And that became what was the middle of the COVID pandemic, right? The business went down, everything was somewhat stopped. Right?
His business went down last year, I think last year November.
And your attorney on your behalf and Andre's attorney went into federal court and had an order created setting up a trust for the benefit of Elena with $485,988 in it. You're aware of that, right?
Yes, I'm aware of that.
And also, that same insurance policy paid off the mortgage on the Bryn Mawr property in the assisted living business. Did it not?
I'm not aware of that.
May I approach?
Yes.
I'm showing you what's been marked as defendant's exhibit number 64. Have you seen this? And you're welcome to take your time and look through it.
Mm-hmm. I don't know about this one. Let me see.
And may I show you exactly what I'm sorry.
This is a paper for me to get temporary custody of Elena.
No, this is the paper appointing a permanent trustee for the insurance proceeds. And in this line right here, if you take a look at it, just these few lines, would you take a look at those, and maybe that'll refresh your recollection.
I don't understand this one.
Okay, just for the record, Ms. Smith is pointing to a reference to the proceeds under Texas Insurance Code annotated in a section number, right? It's just the law provision, a provision of the law. Then it goes on and it's signed by the federal judge. It's actually an agreed order. Do you know what an agreed order is? Mm-hmm. You know, Ms. Brown, on your behalf, went in and agreed to setting up this trust with,
yes,
with
I
the
remember
funds.
that one,
Okay.
yeah. Mm-hmm.
Okay. And that it contains the numbers and what the insurance proceeds are done with. But I'm going to offer.
I don't believe she's a proper authenticating witness. We are bound by the rules of evidence at this point. This is a document that hasn't her. He had to read a whole bunch of stuff to her for her to even understand what it is. I don't believe she's the appropriate witness to offer this.
Your response?
She's a party to the litigation. It's an agreed order. It's obviously from these markings taking off.
I don't think you did it the right way, but I'll admit it. I want to see it.
I didn't have the staple, so that little yellow is just. Thank you, sir. As part of that effort, we were aware that Andre had gone in and waived or told the federal judge he had no interest in the insurance policy, and all the proceeds should go to Elena.
Yes.
Castro.
Just checking. So remaining is 45, so it was $1 million, and it paid off the building or the mortgage, I guess. And then this was the remaining left for the daughter.
And that's included in the document.
And it's in a trust in her account, so she doesn't have access to it right now. Or she's not going to hit when she is 18, or what is it?
No. There's a trustee, and now the trustee has passed from the appointment in that document. A lawyer named Caitlin Bennett was appointed. Later, the trustee is now in the probate deal, but she absolutely has current and continuing access to those monies.
Through the trustee? Through Bennett?
And now the new trustee, but through the courts, actually. Through the probate court, she has
And this will be
future.
And this will be $1,000 a month. It looks like it, right?
I think that it's a minimum of that, and that initially the court was directing in that document what the trustee could make,
$350 a month.
so that there was the least amount of diminishment of the monies.
Okay. State.
Maureen, we heard a little bit about her trust. Do you know, are you receiving any money from that trust right now?
No.
Are you and Cindy Ann having to pay for everything that Elena needs right now?
Yes.
And that trust is not doing anything for Elena?
That money that he's talking about the other day, the ounce, flood out, and I think money I was to use from that trust to get somewhere for Elena to live. Because where she was living at Solitude Court, it's not livable. I think that lawyer is not really made go through the probate lawyer.
Right, can you repeat what you're saying? The last part.
Say that last part again, Maureen, for us.
It goes through the probate lawyer.
But even if there's a lot of money in there, you're not receiving any of that money for your day-to-day needs for you.
No. It was used to pay for somewhere to Elena live.
I'll pass it over to her.
Yes, I don't understand. They're not getting the money, or
If it's that.
That's been our understanding. They're not getting the money.
Judge, it's over in the probate court. Money is there. From the standpoint, by waiving everything, we're not even in that anymore. So I'm just simply pointing out to the court that money is there
And that's still
for
pending?
that purpose.
And that's still pending?
And yes, sir.
Okay.
And there's a guardianship, and there's probate. I simply, the point of the document is that those monies.
That he waived it? Okay.
Thank you, Judge.
That's fine. Anything else?
Judge, just that, from our questioning, these are all, I understand that they may be tied up in probate, but these are all based on the actions of Andre McDonald, that currently they are not getting any money and they are having to care for his daughter now.
That's fine. Any questions?
No questions from the state.
Any more questions? Thank you. Excuse. Thank you.
Thank you.
The next witness.
Your Honor, the state calls Dr. Rosemary Coates. Oh, sorry, I've just been informed she's not a doctor. Just Rosemary Coates.
Your Honor, we're going to have the same general objections that I hear saying confrontation under 702.
Who's she?
Same response. I mean, she is Elena's therapist, so we're just talking about why she has been in therapy with Ms. Coates and what sort of treatment she's providing and why.
This is absolutely a way of in-grounding the problem. There's a confrontation issue here. And these are people that, they may be able to provide some expertise about this condition or how it's treated, but that's not why they're calling these witnesses. They're calling these witnesses to get into the rank hearsay within the child's medical file. And
Just like the last one, that's what they observe or changes in.
My intention is not to get into anything specifically that Elena has told the doctor, but just what she's been diagnosed with, what their treatment is and why, and when it started, and what the process has been.
I know it's affected her big time, so it's not a matter of.
Well, I think, Your Honor, the other thing is under the Code of Criminal Procedure 420373, there's actually mandatory restitution for a child that has been witness of family violence. So, Your Honor, depending on the testimony hearsay from the therapist, could actually charge restitution to cause Mr. McDonald to pay for any psychology or therapy that Elena has had to undergo, and they've been paying that out of pocket. That's fair for restitution.
that's what we're getting at. Is what they need is for someone other than the child to come in and claim that she witnessed something specifically, so that they can make
They're
the
not,
argument
doesn't sound like they're getting into.
No, we've actually already had testimony that Elena was present. Lorena said
Point in time.
that Elena was present whenever Mr. McDonald had his hands on her face.
What's the point of this for a sentencing hearing? If we're going to have a restitution hearing, if the court wants to order restitution,
I'm going to go ahead and allow her to testify what she's observed on her behavior changes before and after. That's it. You raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God. Listen. Go ahead, speak.
Thank you, Your Honor. Good morning.
Good morning.
Could you please spell your first and last name for the court reporter?
Yes, my first name is Rosemary, Rosemary, Coates, Coates.
Thank you. And just as a bit of background, could you tell the judge how you are currently employed?
I'm the Senior Clinical Director at the Hope Center, which is part of the Children's Shelter in San Antonio.
As a part of the Children's Shelter?
Yes, ma'am.
And so what is your background in education that brought you to working in that role?
I'm a licensed professional counselor, therefore I have the background of a master's degree in counseling and guidance, and also a retired occupational therapist.
And I think you said it's called the Hope Center?
Yes, ma'am.
Are you guided through the Hope Center to treat specific types of children, or do y'all treat children in general?
No, ma'am. We're a trauma center. We're there predominantly for the services for children who've experienced trauma and or witnessed trauma themselves, but also if they had secondary trauma and being like family violence, that kind of thing.
And so that kind of is the focus of the Hope Center and your practice?
Yes, ma'am.
And so was there a point in time when Elena McDonald came into your care?
Yes, ma'am.
When was that?
It was in August of 2019.
And was she referred to you by someone?
I'm not sure how the referral came to me, honestly.
And so when she is under your care, what are you treating for Elena? What specifically?
We're going to object under Rule 702, Your Honor. There's been no testimony that would establish this person is qualified to treat someone with the latest condition.
It's a rule.
So you've sent her back on an education already.
Yes, ma'am.
And how long have you worked at the Hope Center?
The Hope Center opened 7 years ago, so this year will be the 8th year.
And so through your training and as a licensed therapist, how many children have you worked with over the years in regards to issues that they may have?
I'm going to say 1,500, but I know it's well over that.
So just in general, you've treated thousands of children.
Yes, ma'am.
So getting back to Elena specifically, well, I guess let's talk about first the intake process. When a child comes to you, or let's talk about specifically when Elena comes to you, what's just sort of your intake process, your general procedure when you're meeting a child for the first time?
Certainly. We bring the family in. The family would include those that are part of the immediate family, but sometimes extended family, or it could be kinship parents bringing in a nephew or a niece. We take paperwork first, so there's an interview that's done just to see if they qualify for the trauma-informed care component of our services. And if they do, then they're acknowledged, then we'll go ahead and start the process for them to have an appointment with an assigned therapist.
And did Elena McDonald meet those criteria?
She did.
And so when you started working specifically, were you working with her one-on-one, or was her family there also?
Started out one-on-one with Elena. We would have a family visit and discuss the case, how things were going, but for the most part it was one-to-one.
And so without going to anything Elena specifically told you,
Yes, ma'am.
in those first initial meetings with her, was just kind of describe how easy or hard it was to communicate with Elena at first.
It was a real challenge.
Again, I'm going to object under Rule 702. I don't think we've established qualifications with this kind of... I mean, look, here's the problem. This is a very specialized medical and psychological condition. It isn't about generic childhood trauma. And we're talking about something that is both fact-dependent, the events that went on at a specific moment in time and place, and the general outcome from those events. And we're offering this person to give some kind of clinician-based litmus test that this is how this particular trauma affected us. We can't separate out the trauma from the underlying condition. At least I don't have any testimony that this witness can separate out the trauma from the condition. What the basis would be.
Response?
Your Honor, she has already said that the Hope Center specifically focuses on children that deal with trauma, and she herself has dealt with children, thousands of children, 1,500 children. And so that's a part of her process. Her process is to see, what behaviors. We already heard from Ms. Applewhite that specifically talked about how that Elena had a drastic change in behavior. And then now Elena is seeing Ms. Coates and the specific reasons as to why she sees Coates. And then also, we're at punishment, Your Honor. We already know that her mother was killed. We know that, right? And so in August of 2018,
Your Honor,
Let her finish. Let her finish. Let her finish.
I do not interrupt you, Mr. Hunter.
Let her finish.
We do it outside.
Counsel, let her finish.
I'm only asking we do it outside the presence of the witness.
Okay, I'm just going to allow it. That's fine. Go ahead. I'm not
Honestly, Your
allowed.
Honor, I don't even know where I was.
Sorry. Well, I'm not allowed.
Yeah, what about my objection?
I deny it.
Can't make of what I or the witness.
No. Go ahead.
So I think, Ms. Coates, you were talking about that initially when you first met Elena, it was kind of difficult to interact with her.
Yes, ma'am.
What diagnosis did Elena come to you with?
Objection, hearsay, confrontation, 702.
No rule.
Initially, she had a dual diagnosis that she started with the case of being autistic, and then it's also complicated because she had post-traumatic stress disorder.
Okay, and so specifically with post-traumatic stress disorder, what therapies are you specifically trained in to treat children with post-traumatic stress disorder?
We follow all of the mandates that are put out by the state of Texas and by the function of our role as being able to be an assessor for our clients. And so with a diagnosis like post-traumatic stress, which is complicated by autism, we have to also call into other situations for them to share the information that they're going to be sharing with us, because the communication is not always direct with them. So sometimes we have to go in the indirect. May I give an example?
You're saying Confrontation 702.
Just ask another question.
Sure. So specifically, what therapies do you use regularly with regard to children that have post-traumatic stress?
Certainly. We use trauma-focused cognitive behavior therapy. Trauma focus is the component that talks to the child regarding what situations happened for them, whether it be with family violence, a car accident, or witnessing to a crime. And so with the trauma, then we work with the cognitive process that your child has. Because it's not always easy for a child to have a checklist of things that they know, so we have to work with them where they are at their level.
And are these therapies that you regularly rely on in your practice in treating children with trauma?
Yes, ma'am.
And are these therapies commonly used by other therapists in your field?
Yes, ma'am. Additionally, there is trauma that we do with trust-based relational intervention, which is a process of working with the children at their cognitive level, but also in a supportive and caring manner.
And I think you had already said that you started seeing Elena in August 13th of 2019.
Yes, ma'am.
And what were some of the behaviors that she was exhibiting that were concerning to her family, that the reason she was brought to you?
Objection 702, in particular, also to the extent that she's testified that she communicates with others and be hearsay confrontation.
That's not offer for the truth of the matter asserted, but just to inform her treatment and why she was there.
So we'll
You can answer.
Could you readdress the question, sir?
Sure. I guess what were the behaviors that Elena was exhibiting that brought her into your care?
She was exhibiting some behavior changes at school, and one of the things they most were worried about is what she was processing regarding her loss of mom. And so we started there, just being able to figure out what was going on. Because her verbiage was very minimized, she did things like crying like a baby, like wah, 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 and rubbing her eyes. She'd walk around the room until she was comfortable enough to be able to do something. So that's the level of care that she started with.
And has she made progress?
Yes, ma'am.
And so what kind of treatments are you currently providing for Elena?
We still provide the supportive interaction with her. Most of the decisions that she's making is for the development of her being able to understand things. She's quite bright. She just needed to find the words for many of the things that she was trying to share.
And about how long did it take you working with Elena for you to see some of this progress that you've seen today?
It was probably a good half year, probably a little bit longer than that, before she was actually able to carry on a full sentence, because she spoke in broken concepts, like, I want that, that's hard, that kind of thing.
Objection, hearsay confrontation.
So I think you said that she spoke in broken
Phrases.
and so has that changed?
Yes, ma'am. She's able to dialogue quite nicely, and she's kind of funny as she does so.
And so does your treatment of Elena continue even today?
Yes, ma'am. And yes, ma'am.
Now, the Hope Center, is that a community-provided service? Is that a free service?
They're not free. They're based on the ability for the person to pay.
Defense.
So Elena's condition today has improved significantly, right?
Yes, sir.
You testified that you have credentials in managing post-traumatic stress disorder and traumatic events in children's lives. You dealt with 1,500 people in that regard. Is that a fair characterization of your expertise?
Partially, yes.
We didn't discuss anything specific to autism. How many autistic patients have you treated at one time?
I'll probably say 700, could be more.
Okay. What specific training do you have in dealing with autism?
It's part of my license, and also I accepted opportunities to go to trainings, additional learning, being able to be a part of a discussion group. It was over about a 6-month period.
Okay. Fair to say autism spectrum disorder covers a wide array of different subconditions. Is that fair?
Yes, sir.
There are some people who are completely nonverbal and are essentially locked in their own mind, right?
Yes, sir.
And some people who have very minimal impact to their daily life from their condition.
But I will say yes to that, but not to Elena. I only can say that in answering your question, that yes.
Yeah, we're talking about the spectrum, correct?
Right.
You would not be in a position to diagnose where Elena falls on that spectrum, right? That would require clinicians' work with additional training you don't have, correct?
I do diagnoses, yes. I'm licensed to do that.
Okay. Of autism?
Of being a licensed professional counselor.
Can you diagnose autism?
Yes.
Okay. And you have not made that diagnosis with respect to Elena, or you have and you weren't going to share that? It wasn't clear.
Say that again?
Have you made such a diagnosis with respect to Elena?
Yes, and that diagnosis has been confirmed by a psychiatrist.
Okay. Typically, that's what would be necessary, is that you would make a diagnosis, and a medical doctor would follow up that diagnosis.
Quite possibly.
Okay. I'll pass the list. Steve?
Just to clarify, I think, Mr. Hunter asked about what your qualifications were, and you kind of rattled off some things we talked about. So you said partially. Could you explain what you mean by partially?
If you're reading it yourself and you understand what the process is, there are several different things that you look for. They are characteristics of the client and what they exhibit. And so some people are on the higher spectrum with have fewer issues, and then those that are more inclined not to speak, not to interact.
And if for some reason, at any point in Elena's care, if you felt like you had become unqualified in any way to treat her, would you have continued with treatment, or would you refer
Objection,
her?
relevance.
He's attacked her as her qualifications in treating Elena.
I don't know what we're doing from both sides here. I mean, obviously, I know any child that gets that loses their mother at that age is going to be affected, and then also that from the defense side, the defendant himself said that she came in the room and asked him, "Did mommy fall?" So any child would be traumatized. So from both sides, I mean, I'll just move along. I already understand this.
Thank you. I'll pass the witness on.
Nothing further.
Thank you. Your excuse me.
Okay, thank you.
Okay, next witness.
State calls Paul Anderson.
It's your last witness.
It is, Your Honor, yes.
I swear you again, raise your right hand. I swear to tell the whole truth, nothing but the truth, so do that.
I do.
Okay, you can have a seat. You can adjust the microphone if you need to. Take your seat ready.
Thank you, Judge. And Mr. Anderson, you're the same Paul Anderson who testified last week during this trial, correct?
Yes, sir.
And you are Andre McDonald's father, correct?
Yes, sir.
And sir, where do you live?
I live in Sheffield, England.
Now, I want to bring you back to when your daughter was born. Where did she grow up?
She grew up in Jamaica, Portland.
In Portland, Jamaica?
Yes, sir.
And Mr. Anderson, what type of child was Andre?
She was the best child any dad would wish to have.
Were the two of you very close?
Very, very close.
Now, how was she academically?
She was excellent. When she was in Jamaica, when I left Jamaica in 2004, she was still attending college.
And what was she studying in college in Jamaica?
She was studying business.
And Mr. Anderson, you said that you left Jamaica, I believe, in 2004. Is that when you went to England?
Yes, sir.
Did you still stay in communication with your daughter?
Yes, sir.
How would you communicate?
We'll communicate by phone, and I'll go to Jamaica every year.
Would you speak often?
Yes, sir.
Now, you said that she was going to school for business when you left to go to England. How was she paying for her schooling?
I send my money to Western Union to my adopted, we call her my adopted sister, because she was the eldest one that was in the household that we live. She is the dean of the Pastor Garden Teachers College, and Andreen was living with her.
So you helped support her educational endeavors?
Yes, sir.
Now, while she was in college, did Andreen have aspirations to continue her education elsewhere?
Yes, sir.
Where so?
She went to America on a holiday trip in the summer, and she told me that she realized that she could transfer from the college in Jamaica to America.
Did she do so?
Yes, sir.
Do you recall which college?
The college that she was visiting is Excelsior College in Jamaica, but I don't know the name of the college in America.
And so when she transferred, did you continue to provide financial support?
Yes, sir. Still.
Now, during this time that she transferred from Excelsior to college in the United States, which state do you recall?
In Florida.
Now, was this before or after she met Andre McDonald?
She was going to America back and forth before she met Andre.
And you said that in terms of the support for her education was provided by you?
Yes, sir.
Now, later on, this judge has heard that she later met Andy, the defendant, Andre McDonald, correct?
Yes, sir.
Now, did your daughter, in terms of her educational aspirations, did you know what those were?
She told me that she was interested in business, and after she met Andre, and they were living in Florida, and when they leave Florida to come to Texas, she said she was interested in, after she finished university, she said she's going to go in catering. And what she did, she told me, she said, Daddy, if you notice in Jamaica, the Chinese, they live upstairs and they have business downstairs. So she said she's going to go into catering, but she's going to use the downstairs of her house as a business, and they're going to live upstairs. And what she did, she said she's going to, because like the business was startup, she said she's going to use Maureen, IMC Smith now, her mother, has the first employee, and at the same time she'll have Maureen to assist in taking care of Elena, the baby, and she'll have Maureen to help, to work in the business. So Maureen came to live with her.
So that's how Maureen came from Jamaica?
No.
From where? From Florida?
Maureen was living in Texas with her other daughter, Cindy.
And then that was when Andre asked to have Marie come and live with them to help raising Elena, as well as also help with the business.
That's my knowledge, sir.
And when the business began, did you provide any support, starting money for the business?
Yes, sir.
Now, did Andre also go to school here in San Antonio?
Yes, sir.
You know what she studied here in San Antonio?
Yes, sir.
What was that?
She studied business administration.
Did she finish her degree?
Yes, sir.
Now, did the business that Andreen helped create, that you helped provide money for, did it become very successful?
Yes, sir.
And this is Starlight Homes, correct?
Yes, sir.
Now, did the business grow to where they had several different facilities?
Yes, sir.
Now, did Andreen ever go back to any of her schools to give speeches in regards to the educational background, in regards to encouraging other students in their educational pursuits?
Yes, sir.
Where did she go?
She go to Norwich Primary School. That's a school that she attended up till when she was 12 years old.
And what type of speeches would she give?
She gives speeches at the graduation. And what they do, they ask her, you know, they try to pay her for her trips or the time that she came, and she will say she don't need any money for that. She's just trying to help, you know, other children.
So she would pay her own way.
Yes, sir.
Did she also provide any other support to the schools?
Yes, sir. She will send computer to the school.
So she would give them computers?
Yes, sir.
Was your daughter involved in any type of charity work?
Yes, sir.
What type of charity work?
She will take time out to go help feed the homeless in San Antonio, Texas.
Do you know how often she would do that?
She says she tried to do it at least once a month.
Now, as Andreen grew older and graduated from school and was running these businesses, would you still take time to speak with her?
Yes, sir.
Would you also, I assume that would be mostly via phone, correct?
Yes, sir.
Would you also come and visit?
Yes, sir.
How often would you come visit?
At least once a year.
Now, you're employed in England, correct?
Yes, sir.
And Andreen with her job here. Did you have a designated time or day that you would speak to her?
Fridays.
Now, you also knew Andreen's husband, Andre McDonald, correct?
Yes, sir.
Would you speak to Andre on occasion?
Yes, sir.
Now, I want to call your attention to a conversation that you had with Andre in regards to an improper relationship he had with a member of the staff at Starlight Homes. Did you speak to Andre McDonald about that?
Yes, sir.
Now, was it face-to-face or via phone?
I spoke to him face-to-face.
Now, when you spoke to him face-to-face, did you ask him about these allegations of him having an improper relationship with an employee?
Yes, sir.
Did he deny it?
No, sir.
What did he tell you?
He told me that Maureen should mind her own business.
And when you say Maureen should mind her own business, had you learned this information from Maureen?
Could you repeat
Had
that?
you learned that information from Maureen?
Yes, sir.
When was this? What year?
That was 2016.
So, Andre McDonald's response was just that Maureen should mind her own business.
That's correct, sir.
Now, furthermore, did you later have a conversation with Andre McDonald in regards to a threat made against your daughter?
Yes, sir.
Now, did you speak to him on the phone or face-to-face in regards to this threat?
I spoke to him, the last time I spoke to him about threat, it was 2018 when I came to USA.
So it
We
was
spoke face-to-face.
a face-to-face conversation. Now, was this a physical threat to her that was made?
Yes, sir.
When you spoke to Andre McDonald about that threat, did he not deny that he made it?
What he told me, it was eye gesturing.
I'm sorry,
Eye gesturing, like a joke.
Did he deny that he made the threat?
No, sir.
He simply just said that it was a joke.
Yes, sir.
Now, Mr. Anderson, you stated that you usually would speak to your daughter on which day?
Friday, sir.
Now, did you speak to your daughter February 28, 2019, a Thursday?
Yes, sir.
Were Were you able ever to speak to her after that day?
No, sir.
Round of applause.
Thanks.
That's the witness.
Thank you. Excuse.
Thank you, sir.
Your Honor, at this time, the state will resubmit all the evidence heard during the guilt innocence portion of the trial, and with that, the state will rest on contract.
I accept that evidence. And defense, do you have any witnesses here? Or do you want to do lunch and then come back? Any choice?
But we'd like to take a break or do lunch.
Okay, let's do 12:45. That's a little over an hour and 10 minutes, and so we'll do 12:45. We'll start with defense.
Defense Exhibit 65. It was actually referred to and identified by him in the trial. We have his mother, Jacqueline Horn's letter. That's Exhibit 60. Defense Exhibit 61 is the sister's letter. Damian Newell, 62. His brother-in-law, Andrew Newell. And 63, Allison McDonald, his eldest cousin, 10 years, goes to the state for the objection.
Your Honor, as to Defense Exhibit 60, 61, 62, 63, and 65, the state has no objection.
Okay, very ready to keep presented.
And may we approach?
Yes.
64 is already been.
Oh, okay, that's right.
May we approach?
Yes.
The court, the exhibits that were just admitted.
Your Honor, also, we would just tender to the court. It's not admitted, and we understand the court's ruling with respect to the statement of Lorna Anderson. We marked that as Defense Exhibit 66, and I wanted to tender it to the court reporter for purposes of
Yes,
appeal.
that's fine. 1, 2, 3. All right, let me read these. And none of these witnesses could be here today, or you know why testify?
They're from out of town, Your Honor, and had to leave. In fact, a couple of their letters actually indicate that.
Oh, North Carolina, Georgia, okay. Davia Newell, that's his sister.
Yes.
I read that at State Exhibit 61. She mentions a lawyer and a lot of the good things about her brother that it's done and support for Alana, along with other things she puts in here. Let's see. Okay, I read Exhibit 60, that's his mother. She was here during the testimony, and I understand she still has a good relationship with Andreen's family. The mother and sister still have a good relationship with the family, or cordial, or I guess for the granddaughter. Let's see. Brother-in-law 62. Okay, I read his cousin's Allison McDonald, Exhibit 63. What's this? Oh, this is his reviews from the military, 65?
That's correct.
The one you questioned on the
Yes, sir.
major or the lieutenant, or? Okay, all these letters say different things, but they all talk about the good things that he has done in his life and with his daughter, and all of them seem to have a sympathy for the victims' families too. They at least address her family also. Okay, I looked at all these exhibits. Okay, any closing arguments on both sides?
I would join the state in offering all the evidence from the actual trial itself and ask the court to take judicial notice of the entire file, including the bond affidavits.
Okay, I will do that. Judicial notice of the guilt, innocence phase, everything has been admitted. Okay, argument?
Yes, Your Honor, I'm going to reserve my argument. I'll let the defense go first.
Defense.
Your Honor, this is sentencing before the court. It's okay if I stand.
Yes, please.
Feel more comfortable.
No, I prefer you to stand. Go ahead.
Thank you, sir. This is a sentencing before the court, and the court sat through all of the evidence. So I think I can be very brief. The jury found Major Andre McDonald not guilty of murder. So I think you need to put that out of your mind, so to speak. That they said unanimously he's not guilty of that. So the act clearly dangerous to human life that causes the death, and the manner and the means, and the whole intentional, knowingly taking the life of another. The jury said no, not guilty. And the jury came back after an Allen or dynamite charge and could only unanimously agree in this case that he was guilty of recklessly taking the life of another. That's manslaughter. So, respecting that decision within the system, that becomes the framework for the sentencing. You know that from the very beginning of this case, that Maureen Smith told you that their fighting was mutual, that there were fisticuffs. You know that this is not a template for the husband abuse of a wife throughout time. We've picked several, at most, several isolated examples from 2016, 2017, 2018. Oh, Andre did this, and Andre did that, and Andre did this. The aunt didn't think it was important enough to tell the prosecution about it in the very beginning, and I think we ably indicated that.
No, and I'm not trying to, I'll let you continue with the argument, but I did hear what you said, that it was left off in the report, and I'm not doubting she says it's true, but I also understand, I do also understand his, it's no excuse, but I mean, that's prior assault that what anybody would be ticked off about, tattoos or cheating. At least in his mind, if I believe what he heard, I think any spouse would be angry. But go ahead.
I mean, thank you, Judge. And that is really my point. That I don't either want to or need to speak ill of Andreen McDonald. You heard days of testimony in this case that told you what the powder keg of the situation was at the time. And that what was really important is what happened in between that master bedroom and the master bathroom. And the hammer plays absolutely no part. What the court found then that is his feet, and I think to this day we don't know if he had on the running shoes that were at the Shell station, and I guess that's what's on because there's nothing else. My point is, you have a reckless taking of a life. You have a range of 0 to 20. You're looking at it.
220.
I'm sorry. 2 to 20. And now let's look at the individual. The individual is 43 years old. He has no prior convictions. He doesn't even have any prior disciplinary proceedings. He's been a respected member of the United States Air Force who reached the rank of major. By all accounts, he loves his child too, and he takes care of his child. And all of that's to say that regardless of what happens today, everybody's life is impacted by his reckless taking of the life of Andreen McDonald. That his daughters, his mother-in-law, his father-in-law, this is a family that clearly cares about each other and loves each other, and that's been pushed into a most horrible, tragic situation. Let's not make it any worse. There has to be punishment here. Everyone knows that. You made a decision this morning that took away the legislatively, statutorily given option of giving him probation. Okay. Then is this the absolute outside edge of a manslaughter where 20 is necessary? Is that for a first offender? I respectfully suggest that it's not. And I respectfully suggest that some of the reasons are that this case took place, whether good or bad, whether it should have or shouldn't have, from just before through all of COVID. And during that time, the defendant was in the Bexar County Jail for much of the time, unable to make bail. And then when, after his third or fourth request for a speedy trial and bail, this court lowered the bail amount, he made the bond. He has at all times been excluded by this court's order from communicating with his daughter. So he couldn't assist in that process or any other process. On his own, in 2021, he went in the fall with his counsel to the federal court because the insurance company wanted to disperse the proceeds of the insurance policy. He waived and gave up any interest in the proceeds in favor of his daughter, Elena. It was absolutely the least he could do, but he did. The rest of the estate is in probate. There's nothing that anybody can do about that. So the court's decision should be tempered by those facts and factors, and the greatest of which is it was a reckless act, as found by the jury. So the most difficult thing, I think, if any jurist that I've ever talked to is sentencing people when you talk about the job. So we know it's a difficult responsibility. But thank the court for your attention and hope that you will give Andre McDonald the least amount that you think possible or necessary to the ends of sense and justice, so that they can take on. I want one more thing that I want to say, and that is that in terms of allocution, don't you believe the defendant's not going to have anything to say to the court, but his allocution is, through his attorney, is that he wants to continue the process of taking responsibility, continue the process of sharing his sorrow and his grief at everything that transpired, but he wants to do it privately and not in front of the cameras and not in front of everybody else. And he proved that before this trial even started, that he was willing to do it, and he tells the court and everyone else that he plans on continuing, because that's where closure is, and that's where healing is. Thank you.
Thank you, Counsel State.
Your Honor, by Andre McDonald's actions, he took a mother, a sister, a daughter, and a friend from all of us. Somebody who was a pillar in this business community, somebody who was an inspiration to those back in her own community where she went back and gave speeches to inspire other children to do as well as she did. Your Honor, we presented evidence in this case of prior family violence committed by that man against Andreen McDonald. We talked about the July 4th incident where he put his hands on her, he scratched her, he covered her eyes as she drove with her own child in the car, putting all three of their lives at danger. You also heard from Maureen this morning about an incident where he chased after his wife, shoved her down, and hit a young infant child on the bed. Furthermore, Your Honor, you also heard from Mr. Anderson today about an incident in 2016, an incident in which he was confronted about having an affair with somebody that worked for the business. The defendant did not deny that. The defendant said Maureen should stay out of his business. Furthermore, you also heard from Mr. Anderson today when he testified about confronting the defendant when he made a threat to his daughter, to Andreen McDonald, where he said, "Oh, I was just joking." Your Honor, defense represents that Maureen came and testified that this was mutual combat. The court heard what she said. She did not say that in any way, shape, or form. She said that the defendant stomped on Andreen and that Andreen did not physically touch the defendant at all. Furthermore, Your Honor, the violent nature...
Sorry, counsel. That's not what the record says. It's simply inaccurate and misrepresentation.
That is inaccurate, Your Honor. The violent nature of this offense, as the court heard, in terms of exactly knowing what he did that day, we will never quite be sure because of his actions to try to cover up this crime. His actions in which he destroyed clothing, hid evidence, set her body on fire. We don't know if he hit her with a hammer that day, if he hit her later or not. From his self-serving statement in an effort to try to justify the physical evidence that was recovered after this defendant heard it, he tries to say, "I went back and hit her with that hammer later." We'll never know. His lies on the stand on Monday, as the court heard, as this jury heard, are completely self-serving to try to cover his tracks. We also know, even if the court were to believe his own statements, he says that he sets her on fire. He desecrates her body. Even ancient cultures treated the dead with respect. He showed no respect to the wife of his child. Your Honor.
I don't think he went back. I don't believe that he went back to. Yeah, his anger, but I don't believe he went back there just to beat it. I think it's obvious he was trying to cover up. But go ahead.
Thank you, Judge. Furthermore, his actions destroy this family and the businesses. As the court has heard, Andre McDonald was a very successful businesswoman. All of those properties under Starlight Homes failed. All of them went under. The house they used to live at, 1042 Solitude Cove, a very nice house, the family no longer lives there. The income stream that used to support this family of four has gone away because of what he did. Not only does it destroy the lives of the family, but it also destroys all of the lives of the people who used to work there, as well as the residents that used to be at those facilities. This is specifically in terms of Marine and as well as Elena, they did not need for anything. They did not want for anything prior to this. His actions have made it to where now they have no more income. A young mother is no longer there, and Marie is now thrust into the role of having to be caregiver in her 60s of an autistic young child. This trust that defense talks about, trying to make it look like the defendant is being altruistic by giving up his rights. What life insurance company is going to give money to the person who caused the death of another? You would have no right to that.
Yeah, that's true.
That's a ridiculous argument. Furthermore, in terms of the business insurance, going to pay anything at Bryn Mawr that was brought up earlier, that insurance is there for that business that failed because of his actions.
Prosecution's testifying.
I'm just going to make an argument. I know all the testimony.
So the prosecution offering essentially evidence not in the record, is that denied?
Let's make an argument. Go ahead.
Is that denied?
No.
This defendant took the most important person in Elena McDonald's life away by his actions on February 28th. The court heard about from both Ms. Douglas during the trial in chief and Ms. Applewhite today the level of care that she was receiving, the love and attention that these teachers were giving her. All of that changed. The family had to move. She was no longer around these people that had cared for her because of what he did. Furthermore, the court heard from Colonel Ayers this morning that he had to be ordered to support his child, ordered to give money to her in November of 2021. And furthermore, you heard from Maureen that that support only lasted for a few months before that discontinued. This man has taken absolutely zero responsibility. He's shown absolutely zero remorse for his actions. Your Honor,
And that exhibit y'all gave me on 440 that shows that much money in there, over $200,000, that was after that he was ordered to pay child support. He still wasn't doing it?
that is correct, Your Honor. He was ordered in November 10th of 2021. According to Maureen, he provided support for anywhere between 4 to 6 months. He had over $200,000 in his account, yet was not providing for his child.
It doesn't make any sense, because I thought the only emotion I saw with Mr. McDonald was about his daughter, so I don't know why he wouldn't do that. But go ahead.
Your Honor, the last memory that Elena McDonald will ever have is either hearing or seeing her mother dying on a bathroom floor because of what he did. I can think of no other punishment that is appropriate but for the maximum. $10,000 fine, 20 years incarceration in TDC, an affirmative finding of family violence, affirmative finding of a deadly weapon, and no contact with Elena McDonald, Hyacinth Maureen Smith, Cynthia Johnson, and Paul Anderson. Thank you.
Thank you, counsel. Okay, Mr. McDonald, you know that I don't even have to tell you this, that your attorneys did a great job. You already know this. To tell your demeanor, reaction after they got you all the murder and down to the manslaughter and just every objection and everything they've done, and both sides they've fought, done a great job. I've had a lot of cases in here. They've done a great job, but now we're down to manslaughter, so I have to consider manslaughter. And go ahead and stand. I'm going to tell you I'm I'm weighing the mitigating on versus, obviously the bad. I mean, you have no criminal history, military service, you become a major in the Air Force, and obviously nothing justifies a death, but I understand the anger if I truly believe you as far as tattoos, or at least you believe it, the cheating, the money in the business, and at least from your eyes that you thought they're going to off me or they're going to kill me pretty soon over there. So take that all as true. I can understand the anger, but still not a right to take a life. In addition, it seems like you had prior to this a good relationship with your mother-in-law, and they're strong, because I've seen some families in here before that have come in here and they're just mad and yelling and don't even want to look at Defendant. They've actually seemed like they still care. At least I can't put words in their mouth, but more forgiving than I've seen others. And not that others are wrong, it just seems like they still care for you. She said you were a smart man, intelligent man, you didn't have to do this. So that was strong of her and the rest of the family members. I think your sister says it here too in the letter, basically can say it better. No prior criminal history, no prior arrest, no record of discipline, distinguished military career, no prior history of discipline throughout his life. She talks about your support of Elena and helping her with her disability or autism. But I also have to weigh that against, what I heard in the testimony is more on the punishment side. I saw your anger. I told you I understand some of it, but I saw your anger where you said you wanted to go hit the bones, even though I believe that was more of just covering up. But that anger of everything that you had heard and cutting off prosecutors too sometimes before on their objections to hearsay. I could see that temperament, and I think I recall Gamber's testimony saying that if I ever die or get killed, it's going to be because of your actions. So she obviously felt some fear there, and I did hear some evidence in prior assaults, even maybe I don't want to say minor because no assaults are egregious, but I didn't see any arrest on that or major bruising. Obviously, this caused the death in this incident, but it's also devastating that you had to cause her death with your child. I mean, at home, coming down, seeing part of it, and being there, and you know this because I watched your eyes. The only time it maybe welled up a little was when they're talking about your daughter. It's terrible that she had to be there, and then with the victim's body with cow bones. That's also sickening to leave her there with cow bones. Again, cover your actions, but to do that with the animal cow bones. In addition, not to top it off, is weighing this against your mitigating stuff, is that you burned her body, you beat it with a hammer, and desecrated her corpse. Like after that, it almost seems like emotional, like a serial killer or something. It doesn't match up with your military career and everything else that you got here. It just it didn't fly with your background. And the last thing that kind of had me weighing is your emotional state throughout this trial. And it's not, I'm saying remorse is, you have to take your attorney's advice, but it's not remorse like I did it or I felt wrong. You just didn't show any compassion or emotion for the defendant's father was up here testifying. It almost seemed like I was watching you, and obviously can't put words into your mouth, but I'm watching you, what I see. And it's almost like I don't say enjoying it, but a smirk. I would think you'd be hands on your head or crying, or because you could see that some of them still care for you. Or her mother up there, it just didn't seem to bother you, and you weren't going to care for the mother of your child, for the death. You just didn't seem bothered by that. In the beginning, you were on your phone a lot and playing with your phone. Even had my deputies ask me if the turn-in officer, no, that's whatever they want to decide over there. And it just disturbed me that the only time you seemed to pay attention is when they showed her bones up there. You were looking like very interested in it again, and not in sadness of some sort. It disturbed me. It didn't make sense with your background and no criminal history. And obviously I know there's appellate issues about getting up on the stand and testifying or whatnot, but I honestly thought, well, I didn't hear, even when he was on the stand through the whole trial, if the attorneys were putting up, if he shows some emotion and it may even help him more. I mean, that's just my personal opinion. I thought if he showed that he had some sorrow to the family and whatnot, it was matter of fact describing, I'm hitting the bones like this, I'm hitting it like a movie, just no emotion whatsoever, describing matter of fact that I'm hitting her, deceased body in the face and I'm giving it another whack. It just defied me in imagination. I thought maybe in punishment he's going to come over here and maybe he will cry and show some emotion. And I understand your attorney's arguments that you're going to say that at another time where you want to do that personal, but this is your opportunity too. So at this point, I'm going to go ahead and sentence you to 20 years in the institutional division of the Texas Department of Criminal Justice. The good thing that you have for you going is you're eligible for parole in half that term, and that's just by law. So that's 10 years or 2 years. Yeah, 10 years. 2 years. And I believe, did he have 855 credit? 55. Okay, so you do have over 2 years credit, 2 years 4 months, so a little over 7.5 years. Doesn't mean you're going to get out. It means just parole eligibility. The bad thing is I do recall you saying that you were angry and that why the hell did this have to happen to me, and like if you were blaming her death for what happened to you. I can tell you that Texas prisons, Mr. McDonald, you can look at me, they are going to be hell. Depending, I do wish you well, I don't want you to get harmed in there, but it is going to be hell in the time that you're there, and hopefully you do something good and seek forgiveness from the family and everybody, and if you do parole out, okay? So good luck. Good luck. You want to any victim impacts?
We do, Your Honor, as to the deadly weapon finding and finding of family violence.
I got affirmative finding family violence, affirmative finding deadly weapon. Okay.
Did you make a finding as to fine, Judge?
No fine.
And Your Honor, we're also asking for no contact between the defendant, Elena McDonald, Cindy Johnson, Maureen Smith, and Paul Anderson.
Your Honor, we would object to that. That's his child. He has a constitutional right. His property rights.
I'm gonna allow the family if they want to take her, if she reaches how she communicates with them, if she wants to talk to them and do that, I'll allow that to them to decide if they want to go to visit the prison or send letters or anything like that.
And Your Honor, as to the other individuals, no contact.
Yeah, we'll have no contact on the other ones that are adults that don't want any contact.
Your Honor, we do have that.
You can proceed when you're ready.
You destroyed our lives. Not only are you a murderer, you are a thief. You stole your daughter's mother. She can only have one this lifetime. You robbed her of a father, a family, and any normal life every child deserves. She's so sweet and big-hearted. One day you will miss the blessings of being the first one she would love first. Despite all that has tarnished her beautiful mind and heart, she's still Andreen's beautiful angel and princess. We can never replace her, but we have been so grateful for her, as she is the closest thing to Andreen we have. But because of your hardships, your daughter needs undergoing, maybe give her lifelong therapy. She suffered so much. Before all of this, she was emotionally and psychologically pure. Today, she suffers from so much because of your curse and actions. She's been severely traumatized. She burns her toys. Why do you think that is? She said and did unintentionally hurtful to others. She picks her skin and pulls out her hair. She suffers from post-traumatic stress disorder. She suffered from trichotillomania. She suffered from dermatillomania. She suffered from constant nightmares. Why do you think that is? You stole a dollar from her mother. Every birthday, major family holidays. She's missing Andreen. You steal her identity by trying to discredit her daughter's character. You stole the sister's only sister. You stole my sister. You stole her right to choose who she wants to love when it was no longer you. We who truly love her would respect who she loves, even that was only you. Because that's what love does. It respects your freedoms to choose. You stole her right to choose. You stole her niece's auntie's privileges that they love and admire her for. She has inspired them to become the best version of themselves. She was such a fun, loving, and caring aunt. You stole from them that too. You stole from her friends the future of beautiful lifelong friendships and partnerships. You stole from everyone who would have been blessed by hard gifts to this world. My sister was on the verge of walking into her calling. You stole her dreams of the future. We all feel that you not only murdered our beloved Andre, you killed her multiple ways, yes, physically, but emotionally in our hearts and minds forever. You killed her more than once. You stole from her unlife possibilities. Above all, you stole from yourself freedom and peace of mind, because you will forever have the same memories you left with your daughter stuck in your head. The very thing you stole from us, you stole from yourself. I want to leave you with Proverbs 16:4-5. The Lord works out everything to its proper end, even the wicked for the day of disaster. The Lord detests all the proud in heart. Be sure of this, they will not go unpunished. Are you proud of the pain you inflicted on so many people? On Andreen? On Elena? I want to say something else. You have destroyed family lives Elena has robbed of her remarkable mother. Andreen won't be here when Elena graduated from high school. Andreen won't be here to impact her wisdom of life experiences to our precious angel Elena. We had to seek counseling from Elena. For Elena, she's seen a psychiatrist and psychotherapist for healing. Elena is she's suffering from PTSD and from trichotillomania and from dermatillomania. She's having nightmares. She burnt her stuffed animals. She used her pencils and scissors to cut and stab her toys. She did attack her teacher and she did attack her peers. She said harmful things. Thank God for church sisters and friends and families. Elena is improving with the love and support she's receiving. It will be a long journey for Elena. It really hurt so much when Elena said, "Grandma, I miss my mommy. Auntie Cindy, I miss my mommy," with tears in her eyes. Sometimes she's really sad and depressed. Maureen wants to say to you, you have torn her life apart when you took away Andreen. She said, "Why do you did this gruesome act?" Maureen cried at times when she thought of Andreen, that she cared for 9 months and felt great pain to know that she's not here. Maureen wants to ask you why you did this. Why choose murder in the first degree? Why not a white paper called divorce? I will never see my little sister again. She was filled with vivaciousness and tenaciousness. Andreen was on the cusp of finding her calling. Andreen Lev was lost in the most harmful, horrifying, brutal, and unimagined way. You might think you can escape the consequences of your actions, but you cannot and will not escape the wrath of God. Last night I dreamt my little sister. It seemed so real. I was so happy to see her. But when I woke up, that's when I realized it was just a dream. The descriptive usage of words you used to illustrate the despicable act of plunging and murdering my sister demonstrated how cold and heartless you were. You hammered her mandible and nape in such a psychopathical way. You stripped her naked in the fierce winter of the night and burnt her body as if she weren't the mother of your child. And then you put the skeleton remains of a dead cow on her body, concealed in your murderous act. In your demeanor, you showed no respect, no remorse, no compassion or sadness in your ruthless action of depravity. Thank you.
Thank you. Any others, Mr. Spears?
Yes, Your Honor.
Andre, you know I love you. In spite of everything, all the evidence, you know I love you. And that love can't change. You hurt me. You hurt my family. I entrust you with Andreen. We have a lot of fun together, you and I. We spoke like brothers. We spoke like father and son. I want to tell you, you hurt me. Because like, when I first met you, it's like I received my son that had died. And now I lost my daughter. And I feel like I lost a second son. But I want you to know, in spite of everything, I forgive you. Where I stand now, I wouldn't hurt you. I will never hurt you. I'll never hurt your family. I love you. And when I say I love you, that cannot change. But you take a part of me. And when I say you take part of me, it's like a part of me is in the cemetery. And a part of me is going to jail. It seems like, I don't know how to express, it's like, it's a nightmare. And sometimes I wonder, when I go to sleep, if that is a real life, or when I'm awake now, if this is a dream. This is how I feel. Andy, I wouldn't like to be where you are this morning. And I wouldn't like you to be where I am. But there's one thing I said to my friends all over the world. Do not try to take any vengeance on any of Andre McDonald family. Anyone, just leave it. Justice have been served. And I just want to say, Andy, I don't know how I'm going to live this out. But I forgive you, and it's your duty to seek God forgiveness. I love you, Andre. I want to tell you, if I've seen you drown, going to drown, I'll jump out to save you, in spite of everything. I love you, and I forgive you.
This letter was written by Elena to Andre McDonald. You killed my mother. You took away my life. And you broke my heart. And you hurt my feelings. And you will pay for what you did. And you will be punished forever.
Thank you. Thank you. Thank you.